So the counsel of the case is in the court number 2.
Hmm?
Counsel of the case is
After some time? After
my
some
lord,
time?
the counsel of the case is in the court number 2.
Was. You tell
So the matter may be passed over for the time being.
yes, after some time.
I am for respondent.
Yes. We'll dismiss it.
That's
We'll
better.
dismiss it for non-prosecution.
Yes.
Heard non-FES for petitioners on call. Mr. A. Apang, learned senior counsel, assisted by K. Menon. K. Menon.
Yes.
K. Menon, learned counsel for the respondent.
6.
Respondent number 6.
Earlier also it was dismissed for default.
Yes. On 09/04/2024, the Disco adjourned the matter on the prayer of the learned counsel for the petitioner, Mr. B. Sibu, who had submitted that Mr. T. Tapak, learned counsel, will appear in the matter, appear and argue the matter. Mr.
Lordship.
Yes.
I was there.
Are you appearing?
Yes.
Okay. Yes, in that case.
Matter.
Lordship, in this case, this is with regard to land matter. This land is a private land. I'm claiming the private land. And the issue is this government. Is that government has on the decision of this village, some village people, some decision has been made to shift the circle headquarters, Geku, from earlier earlier area to the present place. Now, the circle headquarters has been shifted at the present location. And accordingly, Lordship, some of the village people who are landowners, they have donated their land for the purpose of establishment of the circle headquarters at Geku. And in this petition, the writ petitioner agrees with the administrative action of the state respondent.
Are you the landowner?
Yes, not the landowner. I am the landowner. Landowner. Not
You are
the
the landowner.
Yes.
First, show us
Respondent,
on what basis? Show us your ownership, any documents?
Lordship, it is a village land. Village land, they are generally traditionally hold the village land. Generally, on application, generally government grant as per the procedure, land is LPC is generally given on the request of the party, the landowner. Otherwise, land is generally all traditionally as per the custom, as per the practice of Adi. That is there.
That's all.
Yes.
You don't have anything to
I
show
do
that
not-
you are
I
the
do-
owner of the
I
land.
do not have any documentary proof to show that I have a land. But everybody knows in the village I have a land. There were disputes. In this case, another line of submission is lordship that after this donation, land donation by some of the village people, the state government has already initiated acquisition of the land as per the relevant provision of law. But that provision has also already lapsed because of non-hearing of the aggrieved party. Non-hearing of the aggrieved party, no hearing was done. Rather, the government claimed the whole land as the government land.
After the donation,
Lordship,
has it been donated?
yes, donated by some of the village people in the same village.
This is the headquarter.
Yes,
What sort of land it is? It's a headquarter,
Very old town, Geku town.
township land,
Yes,
town land.
yes,
town land.
Has
EAC,
been donated.
yes, EAC is there.
Kindly see, there are the list as per the RTA information. There are list of landowners, and there are series of complaints.
First, you show us what is your right as a committee. First, you cross that you are the owner of the land, which has not been donated, and the government has forcefully occupied it.
One thing,
Then will you enter into the merit.
Lordship, we can see the persons who have donated the land, they are on the list. Those who have not donated the land, they are not on the list. That is the issue here.
What?
Those who have donated the land, they are on the list on the basis of in pursuance of that action, administrative action. The district headquarters area has been, village land has been occupied as a district headquarters on the decision of some village men and some interested group.
It's not a district headquarters, I suppose.
They are the circle headquarters.
What is the locus of your committee? Is it a registered society?
We have not filed this case in the capacity of locus.
Yes.
That the committee, this is a unregistered association
Yes.
who are aggrieved
Yes.
with the decision of the government in occupying their private land.
Your land.
Yes, my land.
Then show us. How do you claim? What is your, right over the land?
Kindly see, Lordship, generally, Lordship, what is the source of land right? Source of land right is generally what I have submitted. Land belongs to the
Sir, we understand.
yes, those who
How
are
the
resided
ownership-
at that village. We have to consider that land belongs to them.
No,
First
we
of-
cannot. If the land has been donated by some section of the parties,
That is why,
we
that-
believe that they are the owners of the land.
that
If
is
you are
why,
claiming that you are the owner of the land, go file a title suit. That's all.
that is why, Lordship, as per the preliminary, because there is a government decision, there is a preliminary notification.
You want that it should be acquired.
Yes, if government, that is every right of the.
No, once the
government-
once the land is donated, what's
Government-
the question of acquisition?
Lordship, I am not saying that government, not saying that the land is a government land. I am saying that.
Obviously,
land is a
you will
private
not,
land.
you will
That
not
is-
say.
That is why
This court is saying once it is donated, when the question of acquisition,
I am not saying that, Lordship.
I am not
Land-
saying that, you are saying that.
Yes, land is a, I am saying that land is a private land and their land,
Which has been already donated to the government.
donation is given by the private individual,
Yes.
not me.
If
My
you,
land, petitioner's
if you
land has-
claim that this is your land, you file a title suit.
petitioner's land has not been donated. This is the issue here. Number one, Lordship, kindly see.
If it is not donated and somebody has donated your land, you file a title suit.
Lordship,
Or else you show us that you are the owner and it has been wrongly donated by someone else who is not the owner. Show us that.
Lordship, kindly see this, written argument in the form of written argument. So I have, that may be taken on record also. I have filed written argument over my submission. In the written format, I have given in written form my submission. That may be heard. Kindly see the page number 18, Lordship. Page number 18 of the writ petition.
Yes.
There is a, on the basis of the this donation by some of the village people, the government has initiated a process for land acquisition under the law, in which preliminary notification has been already issued in the 6th February 2007. But this, after the preliminary notification, the government has not issued the final notification as required under the law.
So it like got lapsed.
It has already lapsed. In the para 6, government has already given here averment, specific averment that already notification has lapsed. Final notification has not been done. That is there. There is a specific averment. And with regard to the private respondent lordship, private respondent is claiming the land that land has been already allotted to them. Whereas I am saying that that land is a private land, government has illegally adjourned my land. Lordship, thereafter I have come to know in the page number 20, kindly see, annexure 2. There are many persons, 19 in number, whose land, the land allotment has been given within the circle headquarters, Gekut town.
Yes.
But out of this land, this is within the donated land, except the land of the private respondent number 6. All these land are within the donated land, for which I do not have any objection. Because I am not affected with this land. Because government that the village people has already donated their land. But on my part, I have not donated my land. This is my issue.
In respect of serial number 2, page 18, with respondent number 6. Yes, serial number 2. So according to you, this 336 square meters of land is belongs to you,
Yes. Petition number 2 and 3.
2 and 3.
Yes.
That's all.
There are so many petitioners. There's a private with respect. I am mentioning this respondent number 6. Respondent number, the land of the respondent number 6 belongs to the respondent number 2, petitioner number 2 and 3.
So this, it doesn't fall under the donated area.
And rest of the area doesn't donated area. This I am saying this there are list of land allotment, land allotted in the page number 20, out of which one is respondent number 6, which is disputed by the petitioner number 2 and 3. petitioner number. Yes, petitioner number 20.
Yes,
And Lordship, on the basis of our complaint, Lordship, there were Lordship and RTA application to so as to know that this ground.
so first let us one by one. You are only agreed by the allotment of proposed allotment of Srimati so and so, respondent number 6.
No, Lordship, that is not my proposal. Lordship, petitioner number 2 and 3 is have a 2 and 3 have an objection. They're objecting the allotment. And rest of the petitioners are affected with the notification, government notification, taking the Lordship without formal land acquisition process, taking the private land without any formal procedure. Kindly see, Lordship, there were series of complaints in the affidavit in opposition filed by the
Please complete the facts and then we'll go to the affidavit.
yes. I would
I'm
like
yet to understand your case.
yes. I would like to refer to government affidavit Lordship. Page number 20 to clarify my case. Page number 20, Annex 3. There is a meeting. There was a meeting. They have enclosed in their affidavit in opposition to discuss the land dispute issue. Land dispute over the circle headquarters.
Affidavit on behalf of
On behalf of Lordship, over not on behalf, over that district headquarters. This
affidavit filed on behalf of
on
whose
behalf of,
respondents?
on behalf of respondent number 4 and 5.
Yes. Tell that.
That is the government land, government side, from the government side.
I'm asking affidavit in opposition on behalf of whom?
4 and 5.
Yes, tell us that.
4 and 5. That is the government.
Where it is?
Page number 20, Annex 3.
Respondent number 1 and 5.
Yes.
4 and 5.
Respondent
Which-
number 4 and 5.
Yes,
That is the government.
yes.
Government has filed one affidavit in reply to in response to this writ petition, in which they have said that in connection with LPCN or Siang Pasum, and there was a series of disputes. And we have filed a complaint that our complaint is not discharged. Never attended. They have acknowledged, the government has acknowledged this public complaint over that circle headquarters. Government land cannot, the private land cannot be taken in this manner. Procedure is otherwise. Your Lordship is aware of the procedure, Lordship. How to take the private land. And then in the government affidavit, page number 30, thereafter, Lordship, on the basis of that land donation, preliminary notification as I have submitted, then on the basis of that, this land dispute, Lordship, in the page number 30, annexure 5 of the government affidavit, they have said that alteration and modification of the boundary description of Gecko Town. Government has tried to resolve the issue at the ground level.
You read your page 20 of the affidavit. second last para of the minutes.
Once land is donated, donor,
While expressing,
Yes.
second last para, page 20
page 20.
of the affidavit on behalf of respondent number 4 and 5, page 20, which you have referred. You have read just
Kindly see.
first two lines.
Yeah.
Read the
While-
second last para.
While second last paragraph, while expressing solidarity on the matter, the House urged all the right-thinking people and organizations to cooperate and come forward and oppose this kind of disruption force to maintain peace and tranquility in the locality. Family, the House urged the district administration to look into the matter seriously and urged never to entertain the claim made by the. This is with regard to the Padun clan. I am not the Padun clan. Even then, Padun has claimed. We are different individual. This is with regard to the directed against the. Padun
Urged
clan.
never to entertain a claim made by the Padun clansmen, but also by any individual or groups claiming
Yeah.
ownership LPC.
We come under any individual.
Yes. So this is goes against you. This minutes supports
Any
the
individual or
administration
group
should not
claim-
entertain such claim.
Yes. Group claiming ownership LPC over land within the
Donated township
township
area in the
area.
interest of all-round development.
That
Yes,
is why,
then next, it goes against you, which you have relied.
that is why, Lordship,
Then
that
next,
my land is not, my stand is very clear, Lord. My land is not within the donated.
donated land of the
My,
township.
yeah,
Then you are
Not-
free. Then
not-
they're free, you are free.
that is why, Lordship, they have tried to resolve the issue. As I have submitted, Lordship. Kindly see. Here is page number 30, kindly see the government affidavit. Government affidavit, page number 30, annexure 5. May I read the content, Lordship? To the Deputy Commissioner, Upper Siang District, Yingkiong, modification alteration in the boundary disputes of Geku Town. Sir, in response to the government order number such and such, I am on behalf of the people of Geku village have the honor to submit herewith the minutes of the meeting along with the list of members, signatories held at Geku, Jamidare on 12th May 2007, according to which the people of the site village have earnestly proposed modification alteration in the boundary description of Geku town to maintain secure in all respects. Accordingly, this Obang Palo, this is a public meeting who was this ZPM of that area.
So you are,
At the-
you are also a member of the signatories, you are also signatories.
I'm none of the signatories.
Okay.
I'm none of the signatories. My land is there. That is why I come here, Lord. Without any donation, Lord, how government can claim my land? That is my issue here. This ZPM concern, although he is not authority, his duty is conducted in the developmental and political activities only, confined to, not in the donation of that private land. The ZPM cannot donate the land of private individual. Accordingly, Lordship, this activities was done to for alteration and modification, Lordship. In the meantime, Lordship, government has started, Lordship, occupying the private land in the name of developmental activities on the basis of public complaint, whereas owner is not ready to donate the land. This is the issue. That is why, Lordship, the boundary of that land, disputed land, required to be re-verified, Lordship. Number one, and land required to be taken as per the relevant provision of law. Procedure has to be applied upon here.
Who are you?
Lordship, I am the landowner, Lordship. I have the right to claim my land.
From where you are saying that you are
I am the
landowner?
landowner, Lordship.
So us,
Lordship, it is understood that Lordship, the land belongs to the people. First of all, it is a fact that there is no any cadastral survey over this private land. There is no land record. Even then, the customary laws govern that village people has a land. I am helpless. I cannot this, submit that land records because government is not maintaining land record. That is issue here, Lord. That may be recorded. That is the everyday problem in this dealing with land matter, Lord. Not only my case, in every case, dealing with the travel land.
We'll hear them. Yeah, yes. Comment,
Lordship, in our affidavit, page number 4, Madam Chair.
page number 4. 4 and 5, respondent number 4 and 5.
Yes, ma'am.
Yes,
Para 6, that with regard to statement made in para 4 of the writ petition, the answering respondent begs to state that complaint against the land allotment of private respondent is,
which one? Para 6.
yes, ma'am.
Yes,
Mumne Bogo, and the claim of the private land of two petitioner mentioned in this para is not tenable in the eyes of the law. When the land has been donated by the entire community landowner for the establishment of headquarters, and when several government institutes assets have been constructed on the said land, claim of the private land by the certain individuals within the earmark area at this junction is not at all appropriate in the eyes of law. So the land was donated by entire public, my lordship, of Gecko Township. My lordship, please kindly come to annexure 2, my lordship.
yes. Page
Page number 18.
18.
My lordship. While acknowledging the above quoted matter issue, I am to draw your kind attention that some of our wealthy people applying for land possession certificate under the central township of government land, which is donated by the entire public of Gecko village. This land was donated, my lordship. This is not a private land.
Private land, but it was donated.
Well, it was donated. And
Why saying this? This is addressed to the
Chief Minister,
Honorable Chief
because-
Minister.
because they were claiming, some people were claiming that it is their private property. Man.
You should write it to Chief Secretary or the Commissioner of the Land.
And my lordship, annexure 3, my lordship, page number 20.
Where is the donation?
My lordship,
Where is the donation? Any deed of agreement? Any donation?
that it was donated.
Yes.
My lordship, kindly come to our page number 10, my lordship.
Yes.
First then I will read. And the final notification would not be issued, however, it can be considered as a government land as per the provision of section 2 of H of Arunachal Pradesh Land Records Act 2000 in the terms of definition of government land as the land in question is a deemed donation. This fact is evident from the letter dated 18/11/2011 submitted by Head Gangura, Opet Angin and 28 others at Gecko area, and also from another letter dated 28/3/2011 from the Sri P. Taku President Pangin Welfare Society, where they have stated that the land establishment for the Gecko Township has been donated by the public for establishment as given in para 6. Further, the Gecko Township was established before the bifurcation of Upper Siang district from the East Siang district, and therefore it is probable that documents like initial deed of agreement might be available in the state establishment of East Siang district.
We'll go and find out. This court will go to Pasighat and find out.
No,
Where is the deed of
Election
agreement?
my lordship.
Hmm?
We have communicated, my lordship.
Where it is?
Annexure 6,
Page
35.
35.
The
Yes.
Deputy Commissioner East Siang district. Documents relating to circle headquarters, Gecko. With reference to above quoted subject, I am to request you kindly to send a copy of following list document, if available, related to certain establishment of Gecko Township Circle headquarters during the undivided East Siang district. Copy of government notification for creation of Gecko Township as EAC headquarters. Copy of deed of land donation agreement or willingness to donate the land for circle headquarters or any other related correspondence like meeting, minutes, etc. made by a person or party highlighting the donation of land.
Yes. Thereafter, it's 2018,
We don't
we are
have
in
any-
2024. You have asked for the documents. It's your duty to find out.
That we when communicated.
It appears that this letter has been prepared and sent to the deputy commissioner all for the purpose of filing an affidavit. 2018, thereafter, you have not pursued the matter. Yes,
My lordship, the land which is donated once is donated, my lordship. The
that is what
person-
I'm saying. Show us where is the donation.
Kindly come to annexure 3, my lordship. Minus of meeting. My lord. There they have said that the land which is donated unconditionally for the establishment of Gecko headquarters from the very beginning.
It's
They
your,
have said-
it's your minus only. What is the documents to show that it is donated?
Documents. I have to take.
You have
instruction.
asked for it, find it out, and then you have not pursued the matter again,
I'll take instruction, my lordship. I'll get the document.
even after 5 years, 6 years. We'll dispose it off. So neither the petitioner could establish that they are the landowner, nor the government could show that it has been donated,
It has been.
except their oral submission. And one more thing, why you have made an attempt to acquire the land when it is donated?
My lordship, there were many claims, like, from some claimants. So it was not acquired totally,
Entire land.
not, and there's some portion. There were some objections from some Podun claimant. Padun claimant.
Yes, yes, sir. That's all.
Yes, my lordship.
No instruction, nothing. You'll not get any instruction. We'll dispose it the matter.
I have been seeing that very town as old as I am. It's older than me. That is the way
Sir, in
Where-
this case, you should not have appeared.
since 1997.
Because it may have some attachment, sentimental and emotional attachment with you. So let somebody appear on your behalf. Just say, please proceed.
Since 1997, on the way to along RK Mission, that was one stoppage for the cooperative bus. I have been seeing that town. But those days,
67,
1997,
97.
97, those days, there was no even circle headquarters. It was just a town. So in my part, I am the private respondent. I have been given allotment. I have constructed the building. They have damaged it. So we have lost FIR also. And the authorities are not finalizing the FIR 2 on 3-4 occasions. I have annexed all the photographs also. From the photographs, it will be seen that not only my building, there are more than 20 others also. That's in a line, single line. And just beside it is the general football ground. So it's very much within the township area. Now, if it is the case that the area is of private land, then the entire area will belong to all the private individuals. Yes, notification, land acquisition are all the formalities that covers up earlier. Earlier those days, those notifications were not applicable. So it's just a cover up to legalize the whole thing. That's the point. Now,
But
If-
you are claiming by virtue of a big
Land allotment.
LOT,
yes,
land LOT.
yes, out of,
Not owner of,
no,
not an
no, yes, that's right.
owner of the land,
Not the owner of the land.
as a LOT.
Yes, out of more than 20 people, LOTs, I have only been chosen as a private respondent.
Because they are saying that your land, where you have been, the land which you have been allotted falls under his their share of land.
There is no statement as such. And there is no prayer as such also. The prayer do not say that. Prayer says that notification should be cancelled. There is no individual prayer. Only in the interim prayer, he says that it should be stayed or cancelled. So interim prayer cannot be taken as a prayer. There has to be main prayer. I have been just singled out, and for that, the remedy is civil suit. Title suit is there, not by this writ court. And it might so happen that particular land is not his land where I have been allotted. And even if it's his land, then it will not be only 20 by 20 square meter. It must be more than that. Just beside me, they are all are in the line.
Yours
So-
is how many square meter? 336.
It seems.
It's okay. You have,
I have annexed.
if the authority can establish that it has been donated and it's within that donated area, if the allotment is given to you, you have a right to occupy.
Yes. 200 square meter. Only 200 square meter.
But in between the petitioner and the state.
Yes.
Yes, any consideration on the representation of the petitioner?
No, Manoj.
Or what is the total area of the township?
Before it was 152, Manoj, and now it's we have not.
Because what they're saying is they are not concerned about the other areas which has been donated by other people. They are saying that their land they have not donated their land, and then the government is occupying, treating it to be donated one, and then and also at the same time you have made an attempt to acquire the land, which has not been brought to logical conclusion, and it got lapsed.
We had made some we have published some notification, but there were some claims from some claimants, so it was not acquired totally. Manoj. Some portion have been.
That was only for those persons that Padu clan.
Yes, Manoj.
Is this proposed? I mean, this notification for acquisition is with the entire land or some?
Because
It's a
notification, they said that if anybody has any objection, they can submit a application. So they have submitted, Manoj, minor submitting that the boundary should be like properly demarcated, verified, modification should be done, Manager. So it was done and it was submitted to the DC, Manager. The land which he is claiming is comes under Geku Township, Manager.
That is his whole case.
If he is claiming, then he can file a title suit in district court, Manager.
You are not saying that it doesn't belong to them. Are you saying so?
We are saying that the entire township was donated by the public.
Public, not by them.
Public, even they come.
Includes them.
They come.
Includes them.
Yes, ma'am.
Includes the
Entire
petitioners.
Yes, ma'am. Entire public.
Is
Sorry.
there any demarcation?
So
Any
for-
boundary demarcation
Yes,
ma'am.
there is,
Yes.
of the township?
sorry for interference, Lordship. Lordship may kindly see the petitioner is page from the petition, page number 5, title, course title. Not course title, the petitioner's name. Petition number 3,
Hmm.
Sri Apak Ijing. Apak Ijing, son of late Boger Ijing. Son of late Boget Ijing. So here, page and petitioner number 4, Kut Ijing, son of late Onak Ijing. Now, in my affidavit in opposition, your lordship will find at page 12, this is the deed of agreement for land donation. Here, at serial number 7, is Onak Ijing, Gambura. Gambura is the
With page, your page?
page 12. Page 12 of
Yes.
my
Deed
affidavit.
of agreement for land donation.
Yes. Serial number 7 is signatories.
Hmm.
Serial number 7 is Onak Ijing,
Yes.
Gambura.
Hmm.
So, and we'll go back to the petition. Petitioner number 4, Kut Ijing, Treasurer Geku Land Township Owner Committee, son of Sri Onak Ijing. Father was the signatory. Now son is before us.
Yes. There's a deed of agreement is there.
Yes.
Government is not with, it's not with the government or what?
Now grandson will again come. The son has come. Grandson also may come. So how long?
Yes. No. We'll hear it.
My lord,
Why, once it is donated and you have accepted the land on donation, why the acquisition is required?
that is
If
in
you-
fact,
if you-
those
even
days
if-
it was not required at all. My lord is aware of the fact that entire town of state of Arunachal Pradesh, it is all donated land. There was earlier no
That's
acquisition.
what I'm saying.
Yeah.
Why you have made an attempt to acquire the land?
Maybe to legalize the donation.
How do we know?
That could be the reason. And my lord, here in fact, what I have seen from the
See,
petition.
once you acquire the land,
Yes,
you'll have to pay either 1894 or 2013 Act. You have to pay the compensation.
yes.
Basically, indirectly, they are asking for compensation.
No, my lord, yes, they may, but they have to show that the land actually belongs to them. I have gone through the petition, my lord. My lord has correctly pointed it out. They have in fact no locus
to file this writ petition. Because
No,
to
of
file
course,
a
they
writ
are-
petition
The
before this
government also
honorable
not
court,
able to show that these are the areas and clearly demarcated and they are. Is it still 152?
In the modification of area is not mentioned now. The earlier,
152.63 acres.
Yes.
What do you say? Sir, since you are from that area, is it 152.62 acres approximately?
Could be.
It's more
Because
than that.
measurement wise, I'm not sure. Down below is Siang River. Then towards Yingkiong, there's one stream, and towards Alo, there's another stream. So in between, and then it extends up to one village called Peram village, and wherein the law commissioner Onit Panyang's house is also there. So up to that area, it's all town. Inside that, the Bijoy Taram RTI commissioner's house, Sobi is also there. And then huge football ground is also there. And this allotment is in between the football playground, and the BRT road.
So according to what would be the approximate area? 152 acres.
It could be.
We'll presume that. Beyond that, let us see that. Have you mentioned the area in the deed? Donation agreement. Yes. 152.63. Yes, you have mentioned it. It is mentioned. Yes, sir, Mr. Tapak.
Lordship, I'm not
According
aware-
to you, what would be the area now?
area
Is it 152 or more than that?
Lordship, our trade is in, there is no registered survey.
Approximately, you must be having.
But
Some idea.
Including whole area, that is a 152.63 acres. As per
Sure.
the preliminary notification,
So you
as
are-
per the government.
Yes. So you are also agree to that.
We want demarcation. Where we want demarcation of our land. By
First,
forfeiting our land.
first you establish your right and the ownership, then we'll come back and we'll direct for demarcation. We understand you may be honored, but it has been donated, 152. That's the reason I'm asking about.
Lordship, there,
You have to see, even if customary, the ownership is based on the customary practice and the tradition. At least you must able to show that these are the areas, these are this
one of the.
amount of area
One of the,
belongs to you. That statement has to be there. It's nothing like, there's nothing.
one of the,
How do you infer?
one of the claim of the petitioner number 1 in 2 and 3 is that land allotted to the private respondent number 6 is falling within the lane of.
See, if disputing that he said, it is with this land, the area 336 has been allotted to respondent number 6 in between the football ground and some other establishment.
I have, in my written petition, I have not given this schedule, neither the.
You have to
government-
give the schedule.
Neither the government knows, nor.
No,
petitioner.
they have annexed some documents that the Gaoburas, the area include the political interpreter back then. They have mentioned the area clearly, 152.63 acres.
Further this.
If you are claiming the land, you have to show
As per the lordship, our.
these are this area approximately whatever
as per the customary practice of others over the this land rights law. Generally.
We are not here to determine that.
Either that can be determined.
That
can
we
be
are not.
determined. And we did not, I am replying this, my senior colleague, Apang sir, is, we did not respond to petition number 4. Okay. Whether Onak teaching has donated to his father donated the land or not. There are 5 petitioners out of which petitioner number has been point out that your father has donated the land. Accepted. And rest of the petitioner, there is no mention that they have donated.
Because he was a Gambura. Gambura represent the village people.
No, Lordship, that is generally that is not the. There is a land generally belongs to the private individual.
And it was donated in the year, which year?
At the page number 8. No mention of date, neither says
Second page,
anything.
second para, 26 February 2008. By the Gamburas and Panchayat leaders of Geku village. Yes. Page 11 of the affidavit of respondent number 6.
And there is no affidavit in reply.
That's all. Anything else?
That's all, Lordship, with regard to that petitioner number, it is, that particular petitioner number 4. Lordship. And rest of the petitioners, Lordship, there is issue, Lordship. If they have donated, there is no issue.
See, this you are not able to convince this court that what is the area of your land, much less the ownership.
Lordship, in that regard, Lordship, I have submitted before the completed authority.
Where it is?
for- Kindly see that. Various representation, Lordship.
Figure? What figure?
Representation.
Yes.
Various representation. Kindly see. And take your Lordship. One of just representation is Lordship. 22 May 2017, Lordship. Affiliation, enforcement. And prayer was made. Conduct speedy and impartial.
So you
Court
first,
verification.
number one, you may challenge the donation, donation. And you may file the title suit. That's all.
This is, we have made it prayer now.
Heard Mr. Titapak. That's all. We cannot keep on
Court verification.
keep on hearing you again and again on the same issue for hours. Your friends are also waiting. We allot the time wherever it is necessary, not unnecessary. Heard, Mr. That's all.
Here, I am submitting Lordship. Here are series of representation pending before the.
We'll consider that. We'll consider that. Heard Mr. T. Tapak, Land Council for the petitioners. And also heard, who is for one? You are for one. The Land Council,
2 and 3.
Land Council, Land Standing Council, Land Management Department. Correspondent number
2 and 3.
2 and 3. Comma MS K Wangmu for 1, 4 and 5. And also and Mr. A. Apang, the senior counsel assisted by Mr. So and so, correspondent number 6. The next para. Petitioners, how many of you?
5.
5 in numbers. claims to be the member of the Geku Town Land Owner Committee, comma, have filed this writ petition challenging the notification dated 06/02/2007, 2007, issued by the Secretary Land Management Government of Arunachal Pradesh, by which an area of 152.63 acres has sought to be acquired for establishment of Geku Township. After being donated by the people of the Geku Circle under Upper Siang district, Mr. The petitioners have also challenged the land allotment to the private individuals, land allotment given to the private individuals by the respondent authority within the Geku Township on the ground that the land, the petitioners are the owners of the land within the Geku Township. The further grievance of the petitioners is for proper demarcation and acquisition of the land of the petitioner. A proper demarcation of the Geku Township area, as well as for acquisition of the land which they claims to be belongs to land of the petitioner. The case of the petitioner, sort of unnecessary details, is that the respondent authority by preliminary notification dated 06/02/2007 has issued for land acquisition of an area of 152.63 acres for establishment of for upgradation of Geku Township, which I list up. Thereafter, the acquisition proceedings got lapsed as the authority had failed to bring the said proceedings to a logical conclusion. Next one. It is contended that the respondent authorities has started proposal for allotment of the land within the Gecko Township to private individuals without proper, which includes the land of the petitioners without there being any acquisition as well as proper demarcation of the area. When did you started your complaint?
Number before filing complaint, we have filed RTI also. We got when the government started over the private land.
That in 2006.
Yes.
Next paragraph. The petitioners, having been active of such action of proposed allotment to the private individuals without there being any proper acquisition as well as demarcation of the land, which includes the land of the petitioner, while the RTI application, and they filed an application under Right to Information Act 2005 on 23/09/2016. Thereafter, they have filed a series of representation to the concerned authorities from time to time. Mr. Hauber, according to the petitioner, as on that the representation of the petitioners have not been considered and disposed of. Hence, this writ petition. Next paragraph. Mr. M.S. K. Wang Leonard, State Counsel, representing the respondent number 1, 3, 4, and 5, while referring to the affidavit in opposition filed by the state respondents. Which paragraph you have referred? Paragraph 6. Submits that the land wherein the Gecko Township has been established is pursuant to the donation by the entire village community, public people for the said purpose. The government has established many assets, including government offices and institutions. The land was donated by the people way back in 2008. Thereafter, there was no complaint from any individuals except some clan so except few individuals, which was also resolved by the Gaburas and the Panchayat members of the Geku area. She submits that petitioner is a self-claim committee. And they could not demonstrate that they are the owner of the land. Even if assuming that they are the owner of the land, they ought to have claimed the same at the very inception of the donation. Christopher. Except for, see, further sum is there, except for one contention, the petitioner could not show that they are the owners of the land. Experiment. Mr. A. for senior counsel for the respondent number 6 submits that the government has allotted, it has been allotted,
Yes.
allotted the respondent number 6 in,
Passbook is also annexed.
in accordance with the applicable act and rules. List of the allotment, the area is of 336 square meter. And she has, you have constructed the house also.
Yes, not constructed. It was, I was putting the pillars. RCC
Now-
pillars.
now-
They have dismantled it.
Okay.
This
On
petitioners.
such allotments is still under occupation of the said land in accordance with the as per the allotment order. Mr. What is your other submissions?
My submission is petitioner, writ petition is not maintainable. And if there is a dispute, then he must go for title suit.
That is senior counsel, Mr. Rapat. Submits that the writ petition is while raising the maintainability of the writ petition, submits that the claims of the petitioner as being the owner of the land with the township, Geku township has been established, is purely disputed question of facts. In the writ petition, the petitioner even could not establish their ownership of the land. Moreover, the land was donated way back in 2008, and they have started they have appears to have started a claim in the year 2016. Therefore, he submits that the writ petition not maintainable, as the issue involved is a purely disputed question of facts. He further submits that while referring to the documents annexed in the affidavit in opposition filed by the respondent number 6, submits that in the deed of agreement, one of the signatory. Where it is?
Lordship, I have stated in my affidavit that paragraph 6.
One of the signatory, namely, it's serial number 7, Sri Onak Ezi, GB, is the father of the respondent number?
Petitioner number 4.
Petitioner number 4. Mr. He draws an analogy that the father of the petitioner number 4 has donated as a GB along with other Gaburas and Panchayat leaders. Now the son is claiming the land. The office to have claimed the land back. In that case, the grandson will also claim in future stuff for which such an claim should be should not be entertained at all. Yes. Then your
My lord, I have the same challenge. In fact, this petitioner is not maintainable because of the fact that petitioner could not establish his locus. Firstly, secondly,
Mr.
even he
Next
could not
paragraph.
demonstrate that the property.
Mr. D come to the standing council, land management department, while adopting the submissions made by the council for the respondents. Submits that the writ petition deserve to be dismissed in limine as the same is non-maintainable on the ground of purely disputed question of facts. That apart, the petitioner has miserably failed to show that they are the owner of the land. That's all.
Yes, sir.
I have considered the submission of land council for the parties. I'll determine. Dismissed.
All right.
Yes.
May I please, my lord? My lord, by last order, record was called.
Do you have the records?
My lord, I brought the respondent, all respondents, my lord.
Have you got the record?
No, my lord.
What is to be done?
My lord, may I
You-
present some
You
more
have
time?
not filed the counter affidavit also.
Yes, my lord. My lord, may I
Have you
present?
filed?
No, no, my lord. They are not.
It's a 2018 matter.
Yes.
What is to be done? What is the issue?
My lord,
What is the issue?
so is my lord, the petitioner was dismissed from the service.
Yes.
And then against that dismissal was challenged before this honorable court, my lord. And this honorable court set aside the dismissal order, my lord.
Hmm.
Then what happened? There was overstay, my lord. For overstay, the petitioner was convicted till rising of the court. And in view of that, the petitioner was dismissed, my lord. Then by this honorable court,
Conviction was till rising of the court.
yes,
Okay. Then on that ground, you,
consequently, then my service was dismissed.
in view of the conviction,
In view of the conviction.
then
Then I challenged before this honorable court.
it was set aside.
Said,
You were reinstated.
yes,
Then
both conviction as well as. the-
according to you, this is not in accordance with the direction of the
Yes,
direction in the writ petition,
yes, my lord.
earlier writ petition.
Yes, my lord.
Why you are saying so?
Because my lord, as per this court order, my lord, they have to fast two order. They have first one order that again they have convicted me, my lord. Then consequential, they have not passed any consequential order, meaning thereby my service, dismissal service is set aside. Therefore, my service is continuing, my lord. Deemed to be continuing, my lord. since they have not passed any consequential order, my lord.
So record was called for.
My lord.
So when?
After 4 weeks, my lord, they are taking it.
4 weeks. Man is still in service.
No, no, my lord. He's not in service because, my lord, it was of
What is the
1991.
post? What is the post?
Constable.
Constable.
CRPF.
CRPF.
And Mr. K. Thariland, counsel for the petitioner. Next paragraph. Mr. M. Katulane, DSJ, submits that in terms of the order of this court. No, submits that he may be granted 2 weeks' time to obtain the records of the case as directed by this court. You have no objection.
No. Last chance, my lord. Since it's
Mr. K. Thariland, counsel for the petitioner, virtually has no objection, but then he phrased that since the matter is 2018, let the respondent be given a last chance to produce their report. You are not filing any affidavit.
No, my lord.
Listen. Come on. Prayer of Mr. M. Katulane is accepted. Accordingly, list this matter after 3 weeks. On which date? On next paragraph. On the next date, Mr. London DSJ to invariably place the records.
My lord. And my lord, may I have a copy of this order may be furnished to me so that I can transmit to the
Copy of this order be furnished to the London DSJ.
reply of this.
May I lordship? This could be part of a timing.
Why?
My senior.
You are supposed to take instruction.
What number one?
Is there any surviving cause?
It survived.
Why?
And also, some of the work is done by the petitioner also, as a bidder, full bidder. What is done by that? What was done? Some.
What is the status of the work? It's a construction of Porter track.
No, sir.
What is your stand?
No, Lordship.
Has it been completed?
Some have been completed.
By whom?
By some petitioners also, Lordship.
Huh?
Some of the
You delineate it, you clarify it,
Yes, sir.
which petition where the work is going to, in that case, we'll dispose it of. And if there's no,
May I lordship?
if the construction is not, and if there's no construction, then we'll ask them for press tender. What's there? You also participate.
Yes, Lord.
It's of 2018.
Yes, Lord.
Lordship.
You are depriving the
Yes,
people from using the Porter track
Yes, Lord.
because of dependency.
There is the completion report is already given, Lordship, but later on, Lordship, the state respondent filed affidavit saying that.
Are you sure?
Lordship, in our affidavit, we have mentioned concerned site engineers.
We'll dispose it after some time.
Yes, Lordship.
You find out.
Lordship.
There is how many? It's a different Porter track.
Lordship, eight projects. Lordship. Eight.
Eight Porter track
Yes, Lord.
out of same tender.
Yes, Lordship.
Same
And
tender,
this
1, 2, 3.
different petitioners.
Yes,
Okay.
Lordship.
You find out which case the work has been completed. It's
Lordship,
of no use.
Yes,
in our affidavit, we have mentioned.
Yes, you find out. You have to tell us. You have filed a composite affidavit or separate?
Additional affidavit.
No. There are 1, 2, 3, 4, 5 matters
But in Lordship, this
Lordship, affidavit filed, Lordship.
on all the matters.
in
Okay.
all
What they are saying?
They say that some of the work the petitioner completed,
Yes.
not complete, but percentage, Lordship, percentage wise, 90 from, and 50 from.
What was the reason of cancellation? I mean, for directing for retender.
It was on our objection, my lord.
Huh?
On our objection.
They were not heard.
Yeah, that the issue.
Petitioner were not heard.
Not heard. That the issue only, my lord. I
That
mean,
is,
it was on our objection, my lord. They was arbitrarily given the tender of, my lord. So on our objection, that was cancelled, my lord.
So you are seriously disputing now.
Yes,
You
seriously,
are
my-
contesting.
contesting, my lord. Now on record, we have.
Wherever it is they completed, we'll ask them to, I mean, even if it's half completed, if it's not fully completed, we'll allow them to.
But then,
complete.
my lord will appreciate, my lord, this petition, my lord.
Huh?
But basically filed on the basis of that, all the work, my lord, was complete, my lord. That is a serious misrepresentation of our court, my lord.
That's why I'm asking what is
Well,
there.
On the record,
Yes.
my lord, we have filed, my lord.
I was in court number 1 on that.
Yes, yes.
My lord, fact, my lord has already seen. The subject matter is very simple. They have filed one writ petition number 280, my lord. And at the motion stage itself, the
You
This-
tell us the facts.
Yes.
first. We'll dispose it of.
yeah, my lord, I am also not interested to keep this pending, my lord.
Yes.
No, my lord,
People are,
in a nutshell, my lord, I'll tell, then I'll indulge
people
my
are
lord. with that.
depriving of the portal track.
Correct?
So we'll dispose it.
Yes.
Yes.
It should be
You
disposed.
tell us facts and
No.
all, whatever you.
My lord, what had happened is in 2018, the executive engineer, WRD, Pangin, plotted an NIT. Accordingly, all these firms, my lord, all these firms, they participated, they were awarded the work. And in the meantime, the private respondents, they were agreed to an extent that their L1 work should be awarded to them. Then in that, my lord, these aware that Ma Binda Express judgment. When it comes to that rule, that highest or the lowest bidder, the bidder cannot claim that work should be awarded. So there was a board has recommended awarded the work to us, and we have executed also. And there was a certificate from, there was a completion certificate also. And in the affidavit by one of the private respondent, that is assistant engineer, says he has issued the completion report under duress. If that is the case of under duress, my lord, at that relevant point of time, the officer ought to have filed a complaint before the police. Yes, I have been put under duress, and then this has been done. It is not like that. So then, my lord, what had happened? Thereafter, the letter of intent was given to us, order was also given to us. Then after 18 months, they filed one writ petition, 280, no, 280, my lord. Writ petition number 280, my lord.
Yes.
Then thereafter, it was heard in the motion stage itself. This honorable court give a directions that by and speaking order, the grievances of the petitioner should be disposed of. And my lord, without hearing us, after 18 months, all the awards were cancelled without giving an opportunity of being heard. My lord. That what we call is principle, Wednesbury principle. My lord. My case is structured on this premises only. All the petitions will be covered. Now, my lord will kindly come to page 18, the NIT. My lord. Page 17 is my locus, my lord. But I have registration. My lord. Serial number 1, my lord, in the first case. This is Dhoni Polo, right? This is Dhoni Polo. This is, my lord, 1, serial number 1. My lord will mark that time of completion.
Kumku.
Yes.
Karo Pandibili.
Yes.
Ah.
My lord will see that duration of completion of the work is 3 months.
Where it is?
It is time of completion, my lord.
Time of completion, 3 months less than.
Yes. Correct. Now, after 18 months, this honorable court passes an order that has created a problem in this case. Now, my lord, kindly come. This is page 19. Annexure 3 is the minute of TEB and acceptance letter, my lord.
All these are the firms who are participating. Everything is clear below.
Yes, then
Yeah, the same thing. There's a by board they have. Now page 24, my lord, will come.
Donipolo.
Yes. Letter of acceptance, my lord. There's 17. My lord, page 25 is agreement. Annexure 4, my lord. This is letter of acceptance. That my bid has been accepted.
No, this is tender so and so, portrait Pangin Moruk, Pangin Moli, Tarak Kebang. This is something different.
No, my lord, same.
Hmm?
Doni Polo, we are on Doni Polo.
No, serial number 1, page 18
Page 18.
is something else.
My lord, for a moment. Doni Polo, 2 work on it, right? 2 works, eh? There are 2 works.
Two working
नहीं, नहीं, it's a Doni Polo.
not so.
This is in respect of Pangin Moruk, Pangin Moli, Tarak Kebang and Foreng.
My lord, I'll just kindly give me a moment here. Moli Tarak Kebang. Yeah, it is serial number 3. Serial number 3 at page 18. Serial number 3. Sorry, my lord. For the incorporation.
Yes. Yes.
Now, next 25 is the agreement between department and the Doni Polo. My lord. My lord, page 27.
Onisaro, what is this?
There's a letter
You
for.
are also the proprietor of Doni Polo.
Correct, correct.
Onisaro, next writ petition.
Doni sir, yes. Next, same nahi. Aliyan. Kakar. Doni sir. Pick. NIT 4 ka na? Follow. Page 27. This letter for commencement of work.
Why to Tony Saro?
Farm owner.
Doni Polo.
Yes.
And you are also, why this writ petition again? In respect of other portrait track.
Yes, in respect of other portals.
Engineer Tony Saro.
Sorry.
Yes.
This is for the NIT number 4. Now, we will kindly see this is the status report. Page 29, there, page 28 is forwarding. That serial number 2 is in respect of this present petition, Doni Polo. My lord will see the status physically completed.
Where it is?
Page 29. Lord. Page 28 is the forwarding, Lord. The forwarding letter by assistant engineer to the executive engineer, Water Resource Division, Pangit. इसका निकाल होता है affidavit in position in para 7 को निकाल दो इसका इसका ना
Physically completed.
क्या ठीक है इसको ले लो फाइल इसको निकाल दो now Manoj, what happens is all the procedures due process of tender was followed until such time Manoj there was no whisper from any quarter about the arbitrary and illegal actions of the respondent party, except or otherwise for a representation submitted by them, my lord. Now, in the meantime, my lord, they files this read petition, my lord. My lord will mark one thing. This. It was filed this week when this order was. That. No. Remember that annexure 7, page 35, Lord. That order dated 13/6/2018 passed by this honorable court in read petition number 218. Page 34 is the fact. Third para is the third para onwards. It is important to be. Two. Lalen ka to. R7 के paragraph 5, page 13, 3 series. They all gave the contradictory report. Para 5, page 13. ये para 5 Lalen. Space पे फेस हेयरिंग करो बोलते हैं जिससे होगा कि
दो काम किया उसका और दे रहे ये सब कुछ हो गया बस कर दो सही काम को ये
they have given the percentage also. 92%. उसको demonstrate कर.
इसको साथ लेना है सीधे ना
Government.
There were so many writ petitions, not only this.
Yes, so many. On
This
the
is-
same cause of
thi-
action.
See, this is in respect of Donipolo. Is it in respect of Donipolo?
दोनों फॉलो करें
Yes.
Against Donipolo or
Against
all?
Volleyball.
Okay. All. Notice was not issued.
Notice was not a motion is made. Now, my lord, kindly come to page 36. This is the impugn order which we are challenging. No, without hearing us, at least the secretary, he is also not the expert of the subject matter. He ought to have given us an opportunity of being heard. Without affording us the opportunity of being heard, this impugn order was passed by taking the shelter of the order dated 13/6/2018, passed in WPC number 280 AP 2018 by this honorable court. They have passed an ex parte order. Now, my lord, the prejudice that has been caused to us, kindly come to government affidavit, my lord. Additional affidavit which they have come. They have 7, no? Respondent number 7.
ये हम ये है 1 million फर्स्ट में तो कुछ
Can this be?
Wait, just wait. When was the tender?
Tender, my lord, I provide, my lord, the NIT latest 4/4/2018.
Okay. Then
Minutes of technical board was
No.
on.
no, it's okay. That work was allotted.
आपका contribution
Allotment of the work.
Allotment of work, my lord, that means acceptance would be 17/5/2018.
सब कमिश्नर की
Office letter on censure. Acceptance is
Acceptance is on 17/5/2018.
agreement.
Agreement was on 28/5/2018. The commencement of work was on 28/5/2018.
Yes.
6. Now, kindly see, my lord, I've seen this impugn order. Now, this writ petition was filed after 3 months, and the stipulation time given was 3 months to complete it. Meaning thereby the work was already completed, and that their grievances was not redressed by the respondent authority. They have come taking shelter in this honorable court, and this honorable court was pleased to pass that particular order, pursuant to which this impugn order was passed on 10 October 2018.
Was there any interim order?
Yes, Lord.
Interim order was there.
Interim order
Any interim order?
we have interim order in this.
No. Earlier, this 280.
2018, there was no interim order, my lord. Simply gave a direction. My lord, you flip back to page 34 itself. Of the order dated 13/6/2018.
Hmm.
अभी पे बोलते हैं इतना भी अभी तो नहीं work on this and other work to start it. It completion reported. It is
Should have been given the opportunity to the respondent also, since it was disposed of at the motion stage.
Motion is still. No, my lord. The simple point to my mind is, at least some opportunity could have been afforded to us, so that we can place our point of view before the competent authority who has passed this order.
Hmm.
बाकी का status report we can. My lord, will have this affidavit in opposition.
Yes,
Additional affidavit filed by respondent number
7. Who is the 7?
7, assistant engineer.
Okay, where it is?
affidavit no question. My respondent number 7.
Additional affidavit.
Yes, respondent number 7.
Additional affidavit.
Affidavit. Yes, affidavit. Sorry, it's not digital. I oversighted with the word.
8. It is. Seven. Respondent number 7 or
7.
Yes.
Below page 30.
Hmm.
There was a so-called notice probably, and was sought some explanation from this gentleman.
Hmm.
Well, what is more disturbing is, when we come to serial number 1 in the box, construction of water trade at Pangil, Moru Pangil, Moli, Tarak, Tawang, and Korang. Works on Tarak village executed and others not yet started. But this exactly runs contrary to the status report which they have furnished me, my lord. That is, my lord, this is after 2009. I don't know. My lord will have this page 28, my lord. The status report which we have there. Work complete, 92% physically completed. It is not appreciable, my lord. This kind of documents are being fabricated by the government officials.
It's the same officer
Same officer, my lord.
who has issued this
Yes, who has issued at least
completion.
completion report.
Page 28,
Page 28.
29.
28 and 29. 29 is the one, my lord.
I beg to state that the completion so and so 27 2000.
Physically completed, my lord. The status.
After receiving verbal completion reports from the contractors of the site under duress. Are you so influential?
My lord, kindly see. One, my lord, what I beseech, my lord, would be to give a thought on one particular point. Law is well settled that government cannot go against its own record. This particular officer has given the documents, completion report below section 3 of the Land Act comes that binds a person so that he cannot make a false declaration. Anyway, that the concept of perjuries are also there, but I'll not press on anything on this. What I'm trying to point out is the malicious action of the respondent authority. Why are they trying to blow hot and cold? And at one time you say that the work has been completed, and another day, after 1 year, you come and you say that these things. I'm sorry, my lord.
Double engine both was found to be broken and inaugurated earlier. What does it mean?
I don't know, my lord. This
What is double engine?
double engine, maybe both, my lord. I don't know what is this. We are technically not
Is it
competent.
connected to the work?
Connected to the world.
Connected. Yes, what is the state of the government?
As per our affidavit, there are many packages. Some were incomplete, some were completed.
No, we'll go one by one.
So
This writ petition, 578. Donjipolo Enterprises. That's why I have asked you, have you filed a composite affidavit or separate affidavit?
in our additional affidavit, Donjipolo Enterprises, that is in this, page 7. Photograph was submitted by the villages, but there was no reports from the site engineer only. That's all.
No, that may be the reason, but then you have
Yes,
issued
there
a
is-
completion certificate. We have said it's completed.
Actually, Lordship, in this regard, actually, these are all under SIDF. Therefore, actually, it should be the deputy commissioner who should have monitored the entire progress. But since there was no report, we can only.
And the of course there is a direction from this court, but then it was the work was supposed to be completed within 3 months.
Lordship.
After
From the affidavit, it can be presumed that almost directly after issuance of that earlier tender, most of them already have started their work, and by the time of filing this petition, I think most of them have either completed or they have carried out 50%.
sir, we want whether the exact status whether it was completed, because as per your own showing in the affidavit, I mean in by issued by your engineer,
Lordship.
it said completed.
Lordship.
Page 28.
Yes, yes, Lordship. In this case,
It says clearly
except
physically completed.
except
What does it mean?
Except at one portal track at Sitan, artwork yet to be executed. Most seems to be completed. Lordship. Here, physically completed status report, Lordship, at page 25. By this, so it's all says is physically completed. Lordship.
Physically completed means what?
I think physically completed means the work
And,
was
and,
completed.
and the same officer is filing an additional affidavit saying that under duress it was issued. We have given the date of site visit also.
But Lordship, as for affidavit, we have not said that point.
Private respondent.
Respondent number 7, he is a private respondent.
Yes, private respondent. 7 private.
7 private.
No,
7 is private.
it's a project about 2018.
18, my lord. My
Have
lord,
you got the payment?
No. Well,
If you have completed, why you have not been paid?
well, I know instructions on that. I cannot.
That's the reason.
Huh?
Can it be carry forward? SIDF.
No, well, it's a time bound scheme,
Hmm.
but then now I have legal documents. I have duly completed all legal formalities. Whether or not the state has to pay. That's for another course of action, law. Appropriate.
No, I just wanted to know, once the project is over and it's no longer, I mean, what's the use of deciding the matter now?
Actually, no, that there is a provision of reappropriation. Can you give me the constitution? I think 203 or 233.
No, we'll not go deep into that. So
No, I just.
it's there, they will look out.
Just for the academic purpose, let me see what.
So you have to make your stand clear whether this has been completed or not.
Lordship, our is a bit, but as per record, completed. Lordship. Affidavit is a bit confusing.
204, appropriation. It can be appropriated, yes. I'm correct.
But Lordship, the funds usually it is dealt by the deputy commissioner.
There is,
But the deputy commissioner is not a party here. So
I have already advised my client, subject to the outcome of this petition, we shall initiate appropriate legal course of action.
may I submit, my lord? May I submit, my lord?
Yes,
I am in all case, my lord, I am for respondent number 8, my lord.
8.
Yes, my lord.
Yobo and Enterprises.
Yes, my lord.
What about others?
First thing, my lord, I would like to clarify.
Other private
Ms.
respondents?
Dangin was appearing,
Okay, yes.
but my lord, otherwise affidavit is there.
First thing, I will like to clarify, my lord, agreement, my lord, in this case was drawn on 28/5/2018, my lord. Now saying that, my lord, this court interpret after 18 months, my lord, is a wrong submission, my lord. The court of this order was on 6, my lord, 13/6/2018, my lord. Just within 15 days, my lord. Now we made representation, my lord. This agreement was drawn on 28/5/2018, my lord. We made representation to the authority on, my lord. authority on 4/6, my lord. Just 5 days after, my lord, this agreement was done. My lord.
But then the impugn order is passed in October.
Yes,
End
ma'am.
October,
October, my lord.
after 4 months,
4
5
months.
months.
That's true, my lord. But I just clarify that the submission was made, my lord. It was cancelled after 18 months, my lord. That would be contrary to the
Anyway.
record, my lord.
You
Now
have-
coming
may
to my
have
lord,
approach within time, but what he is submitting, what he has submitted is that impugn order has been passed for retendering after completion of that
no, my lord. That's why, my
3
lord.
months period, which is required under the as per the tender, and whether we agree it or not, according to him, since the completion period is 3 years, 3 months, they have completed
That
and
is
supported by page 28.
that is the exact point I am making, my lord.
Yes.
Now, left about some reply of the state, my lord. The petitioner, my lord, need to come clean to the court, need to come clean in the court, my lord. Now, they filed this writ petition, my lord, by saying that they have completed the work, my lord. Now, if my lord cannot turn to my affidavit opposition, my lord, at page number 13, my lord.
Your page affidavit by respondent number
8, my lord.
Yes.
8 number. 8,
Ah.
my lord.
Page
8, my lord.
10,
Oh, 13, my lord. 13, my lord.
15.
Now, this is by the side of the assistant engineer, my lord. The report is 9 July 2019, my lord. Now, the actual or progress, I am reading from Sir, my lord. With reference to the above, I beg to state that the completion data such and such was issued after receiving verbal completion report from contractor of the site. The completion certificate was given under duress. However, on site visit, the work were found not to be started. Hence, no status report was submitted. The double engine boat was found to be broken and inaugurated earlier, before the tender, earlier in the season. The actual work progress submit work are as follows. Now, only in terms of porter track at Bangin, Moru, Modi, Tarak, Rebang, and Koreng, my lord, work on Tarak bills executed, other not yet started. In terms of work, porter track at Komsing, Kumku, Karo, Pangi village, work on Komsing, Kampu, and Karo executed, Pangi not started. Of 3 scheme not started. Now, if I correctly understand the sum and substance of the affidavit of opposition filed by the state respondent, my lord, this document is supported by state. What the state affidavit say, my lord? State affidavit, my lord, say, my lord, the necessary my requisite, my lord, for the work was to geotech, my lord.
Who has filed the state affidavit?
Additional affidavit, my lord. I have just gone to, my lord.
No.
They
That is
never
the-
accepted. They are
Who has
saying,
filed the affidavit on behalf of the state?
state, my lord, it is joint secretary, my lord, WRD, my lord.
So
Now, some and substance were state affidavit, my lord. What they are,
they are
if
saying so.
they are saying, my lord, so my
They are saying the same state.
no, they are not making in explicit term, my lord. But then they are saying, my lord, if some and substance of this affidavit, they are saying, my lord, is though, my lord, some completion certificate of there, my lord, but they the requisite, my lord, geotech, my lord, and there is a issue of duplicacy also, my lord. The documents, my lord, photograph, my lord, annexed in this affidavit opposition, who is submitted to the villager, my lord. On site verification, my lord, there is duplicity, my lord. There is the state of the state, my lord. If I correctly understand the sum and substance of this affidavit, my lord. State affidavit, my lord. Additional affidavit, my lord. They never said. They affidavit, my lord, start a specific start from, my lord, at para one itself, my lord. Para one, page 2, my lord, they have say. The last para, my lord. Since the work where neither geotech coordinated nor the photograph of a portion work were submitted, a letter was issued to the Office of Assistant Engineer Water Subdivision Bowling Pangin Beach to submit detail of the project along with the photograph. A letter from the chairman of SDF committee, the Deputy Siang District, when it clearly mentioned the geotech progress site to eliminate duplicity of the scheme has to be enclosed. In reply to above that status report with such and such was received from assistant engine water resource supply, wherein the status work has been reported as under my lord. Now that some package one, my lord, protecting a trigger, my lord. Sitang jungle kira in progress. At the XC, my lord, port package 4, no report submit, no report submit, no report, yet started. 7, my lord, protect at bugging at pocket area, protection wall at bowling. Now, after that, my lord, at page number, they are saying a completion report of HDF procurement of board in its decision has received from the proprietor of MSKT Enterprise. A photograph of completion report from the head Gambura was also submitted, which is enclosed here with the producer. The photograph taken of the board during inspection has been enclosed with self-explanatory. 2 more completion report along with photograph has been received from the villager of Komsing, Pangi, dated 25 June 2018, stating that the work has been completed in response to SIDF package number of portrait track at Komsing, Kumbu, Kara, and Pangi. However, neither official record of the coordination of project site nor the official report in form of photograph site are submitted till date, my lord. They are never saying that those contractors are submitted. This they have by this
2024, what we can do now?
At this is my humble submission of this, my lord, matter be remanded to competent authority, my lord, giving them an opportunity, my lord. If my lord, they get by opportunity all, my lord, respondent, my lord. If they have completed, if there is let them pay, my lord, and leave out if is still punished there, that will be retained. That will do, my lord, I believe, my lord. If they were given opportunity, my lord.
Yes. So according to direction can be given remanded back if they have completed.
Yes, my lord, they need to pay, and
Matter ends there. If they have not completed,
and then the punish there,
the remaining portion should be returned. That is what you are saying.
My lord.
Just wanted to know the clear stand of the government.
Yeah, my lord.
They are neither here nor he is not. Who is representing respondent number 7?
7, my lord. He, my lord. He, my lord. But some assumption, I understand, my lord. They are never accepted that they are completed, my lord. Though some documents is there, my lord, photograph, my lord. But there is allegation of duplicity, my lord. Their stand is dead, my lord.
MS Engineer Ointamu. Is the person? No.
No, my lord. This is one of petitioner, my lord. I'm
No, who is respondent number 7?
Respondent.
7, my lord. My lord, he has represented, my lord. I am in my lord. One of my lord, this private respondent experiment.
Let can we come to the annex the affidavit of respondent number 2, state affidavit.
There is nothing in this affidavit.
Let us see. When you have to make the statement that completion,
No. Yeah,
which paragraph?
Me?
Yes.
Yeah.
Which paragraph you have
petition,
statement in the writ?
paragraph. Completion certificate.
Yes.
In exercise 6 correctly. In exercise 6. In exercise.
In 557 days, para 8, my lord, they have completed, my lord.
Para 8.
Now, this statement, my lord, is a wrong statement on oath, my lord. Once that is established, my lord, this read petition, my lord,
This is not such
not,
matter
not,
of the private respondent.
not likely to be, my
Whether
lord,
it is
hard on
right-
merit, my lord.
Right?
On
Whether
that
it-
ground only, my lord, this case can be dismissed, my lord. Once, my lord, wrong appear, my lord, they have come with unclean hand, my lord. So in that ground only, my lord, this petition liable to be dismissed, my lord.
Completable. Say it or not.
My brother was not able to overcome the page number 28 and 29.
No, my lord,
Yet,
sorry, my lord.
making a very fancy
On
argument.
their completion certificate, my lord, I have a file counter affidavit, showing it, no, that was issued on duress, my lord. Now they have not by reply, my lord, anything, my lord. Now that become, my lord, admitted peg, my lord. My contention, my lord, is not reverted by them, my lord. That become admitted peg, my lord.
You made a statement in paragraph 8,
Yes,
paragraph 8.
yes.
Comment now, right?
What is this? What is your reply in the para 8?
In reply to para 8, it closes documents, my lord.
Hmm?
Para 8, my lord. In dear para 8, I have filed this reply, my lord, saying that, my lord,
My lord, there are government affidavit, respondent number 2. Page 2 is there, my lord. Page 2, paragraph 4. They justifies the status report of 22.
Department is in receipt of the status report 22/6/2016. What is this? Huh?
I think this is typographical mistake, my lord.
Yes.
Also department, I think.
That is department affidavit, they can justify. But from a my lord, this is
Appears to be
should be 18, my lord.
typography. Yes.
18, my lord. Where the status report is 22/6/2018. By 16, there was no course of action.
They are not saying anything that it was issued under duress or something like that. They said they have just received the status report.
Yes, ma'am.
Status report means this is 22/6/2018.
yes, my
It
lord.
cannot be 2016.
But I have also placed on record, my lord.
Who is this issued this other, who said that under duress is what issued?
That is concerned assistant engineer, my lord.
Who
In
he
reply,
is now? We'll
this
call him.
this is a official record, official letter, my lord, retained by the assistant engineer to the EE, my lord.
They are not saying anything. How you have procured this?
How he is privy to that document.
My lord, this is I have made a categorical statement, my lord.
Obtained and
Date-
manipulated the whole record.
Sorry, my lord, that is not my
That-
lord.
that is not
I
correct.
my statement may be look into, my lord. I have made a categorical statement, my lord. I have in response to this, my lord, a particular
Whether the
contention,
question
my lord. I have filed RTI application, my lord. Now, in terms of that RTI, if my lord kindly turn to my page number 4, my lord, my para 5, my lord. In regard to statement made in para 8 of petition, the deponent on the basis of verbal the assistant engineer author division is in the BSM has issued the completion certificate dated 22/6/2018, even without inspecting the worksite, was revealed through the RTA application dated 1/2/2019 filed by the deponent, wherein the executive engineer water resource division Pangan bid dated 4/1/2019 sought for explanation from the assistant engineer the WRD division Pangan in connection with the contradictory statement regarding status of the SID project. In response to the query of the EE, water resource.
I have understood whether
lord.
you have procured or not. It's not the issue. Issue is whether state is not saying anything. They are admitting the completion certificate,
No,
saying that we have received the status report.
status not they are not.
Yeah, status report means what? 22/6/2018. It talks about
My lord,
completion of the project.
if I correctly understand
It's
the
28/29.
specific statement para they are saying, my lord, the deponent beg to state that the department in receipt of the status report dated
Ah.
22 of the following project
Yes,
status report.
yes.
However, as per the order of duty with the Pang the port,
This you ought to have been
all the
monitored.
project has to be properly geotech with quotation
Monitoring ought to have been done by deputy governor, what they're saying. They are not saying that it is not,
during after completion. My lord.
We'll take up tomorrow. You make your stand clear.
My lord,
Alright.
I beg your lordship indulgence in mentioning item number 10, my lord. My lord, item number 10, my lord,
All right.
this my lord, this matter be kindly be taken up after 2 weeks.
Just wait.
I'm sorry.
Yes, do you stand by what you have stated in the affidavit?
Lordship, yes, we will.
That the works is completed.
No, Lordship, as per status report, some work are.
What is the status report?
Additional affidavit.
Who has filed the additional affidavit?
Lordship,
Private respondent number 7.
How
Joint
can you?
secretary.
Huh?
Joint secretary.
No.
Additional affidavit.
Yes, my favorite.
Where it is? Respondent number 7.
2, my lord. By respondent number 2, my lord.
Where is
Additional affidavit.
My lord.
Where is that?
Find out additional affidavit. We'll continue at 2 in that case.
My lord, I beg to mention item number 10, my lord.
Page 52.
Here we have, what we say, on the status report. From our 40%, 26% completed. From 45, 60, 89, 87, 86, 80%. For other,
What do you mean by others? What about this present writ petition?
ये नहीं है प्रेजेंट पांगिन मोबू के हाँ ये दूसरा का है सर डिफरेंट ये का
This is different. Okay, in the P26, this is physically completed. Yes. 23 million.
Of what?
Yes.
Of
This
what?
particular word, Pangin of this writ petition. Pangin modi to break it. Serial number 4. By March 19, it was physically completed. मौलिक तरह से पैकेज नंबर 3 नहीं पैकेज नंबर 3 4
What I mean is that there are many, again, so many incomplete.
See, we are dealing with first writ petition. Be clear about this first, then we'll go to the next. All.
Yes, all, it is indicative of.
What taking?
No, all. I'll show you. Your page 30 also was there. Come to page 30. The other way. These are different.
ये comprehensive affidavit file किया जिसमें फिर सब के लिए लेकिन
Do your homework tomorrow, come back, we'll take it up tomorrow. This writ petition, in respect of each writ petition, you'll have to work out. All right? How much they have completed. Not in lump sum. Because if once if it is completed, what's the use? How can we direct for retender? And if it is not completely, started, or if it's not been done, no work has started, then we may think about it. So for that, we need a clarification from you. You take up the first affidavit and then additional affidavit and work it out. Sir, in that case, we'll ask this officer to implead. We'll implead them and come ask him to come to explain. See, before it is completed, how can he issue an status report that it has not been completed? Because their other documents which they are relying, including government, is of 2018. Yours is 2019.
Improvise official letter.
In that case, you implead this officer.
No, my lord, I'll not, because anything, my lord. The timeline is 3 months. Within 3 months, we have done it.
No, we don't know.
And then you
We don't
give the
know.
completion certificate.
Yeah, what they are saying is under duress.
No, my lord. Under duress, the government affidavit is not there. It is the private respondent who brought that under duress.
That's the reason we would like to see his stand.
My lord, it's my lord domain. I cannot afford, even by a stretch of imagination, whether I should do this way or not. If my lord wishes, if anything falls down from my lord, then I have to comply with greatest respect, my lord. Otherwise I know the consequences as well. Now,
Which documents you are relying? The documents you are not, you don't dispute in clear terms, you are not disputing the documents which he has relied. Para 8, right? And then you are filing a documents again in 2018, showing some percentage of completion. No, we'll go by one. you do one thing, you work it out, whatever is the affidavit for each writ petitioner or each petitioner. What is their package number? Then the area of motor tracks.
I have already.
Now, how many it
You
has
want
been?
the-
What is the status of or completion percentage?
The three wise package number. You can keep this. Otherwise, we have worked out everything.
You have to make your stand very clear, not in lump sum.
Correct,
Because
correct.
every this is a separate writ petition. The issue may be same, but the facts is to be clear.
But issue fact, it is similar, but the percentage of the work which they are disputing. But the.
See, at this point of time,
Correct,
after
correct.
6 years or 5 years, we will have to know the actual position. You talk to, you prepare on the basis of this affidavit and you have a word with the engineers.
Whether that engineer is there or not. Executive engineer, I know he has been transferred out.
You know everybody, where he is and how they are.
But almost being part of the system.
Yes, when do you want? Tomorrow or next week? Monday. Monday will dispose of on Monday.
Yes, yes.
All right.
And
Let him have his own. I think he might. I think he was busy last night. Tuesday. Okay,
not
Tuesday.
the hearing day also.
Don't miss on Monday and Tuesday. Monday.
Yes,
You do your homework.
Tuesday, no?
You go through it properly, the state of the government, right? And then if necessary, you have a words with the engineers and the latest status regarding these documents as well as the latest status. Because the officer has issued two contradictory, the status report.
Fixed responsibility.
And whatever the in the impure order there is some the inquiry has to be caused against those officers. Have you gone through the inquiry? The impure order. Can you, if you, sir, if you didn't go through the impure order, how you defend your case? Or are you considering that this is wrong? Page 36, 37. You take instruction on this also. Heard Mr. Titi Taran, counsel for the petitioners. This is item 327, huh?
Until further order.
Also heard Mr. Land State Council and Mr. El Perme for response. Respond number 8. Yes. After hearing the matter at some length, come on. Mr. Iri Ramlan, additional senior government advocate. Respond 2 days time to go through the affidavits filed by the state respondents, and also to obtain instruction as regard the latest status as well as the inquiry against the officers which has been directed by impute order. What is that impute order? Impute order dated
MP
2018 by the secretary. What is that? Water resource.
Water
WRD.
resources.
Come on. You if possible you prepare a one-page the thing showing the status or the completion, work progress, whatever, showing the each petitioner's this thing work separately, and then get the instruction on these two issues, status as of today, because these were prepared in 2018 and 19. And then the inquiry report, inquiry which was directed against those officers who were involved in the tender. Don't miss it, huh? We are disposing on Tuesday.
Interim order to continue till then.
Interim order was the list will continue.
All.
My lordship. Lordship, this is the application under 438 CRPC. Lordship, FIR is at page number 14. May I read, Lord?
Yes.
Sir, I, so-and-so, daughter of so-and-so, resident of at Itanagar C Sector 1, at around 3 a.m., have so-and-so address at Bagetinale Nirjali. He has been treating me, physical assault, harassment, violation, and attempt to murder with me at CV Blaze, UP near Tea Garden District, Papumpare, at T&J Resort Camp Sport. So kindly request you to legal serious action against him. This is the FIR, Lordship. Accordingly, the Doimuk PS case number 43 of 24 has been registered under section 341, 325, 354 IPC. Lordship.
Yes.
Only otherwise 354 is only the non-bailable section in this case.
354.
Yes, Your Lordship. And its punishment up to 5 years.
Not Mr. Aringo, learned counsel for the applicant. Accused, Mr. This is an application under section 438 CRPC 1970. Praying for grant of a privilege of pre-arrest bail in connection with Doimuk PS case number 43 of 2024 under section 341, 325, 351 IPC, 1860. Call for the case diary. Scan copy.
Yes, Your Lordship. Scan copy of case diary.
Scan copy of the case diary. Mr. T. Lan Edison PP. Appears for the state. Next one. Next one. Having considered the nature of allegations. Come on. Then the submissions of the learned counsel for the parties. Pending production of the case diary. It is provided that in the interim, in the event of arrest of the accused, applicant accused namely Sri Lokamtani, within bracket Antony, shall be released on bail. In connection with the so and so, huh? The accused applicants, namely so and so, shall be Lokamtani within bracket Antony bracket close, shall be released on bail on furnishing a bail bond of rupees 15,000. Considered like a month. To satisfaction of the arresting authority
Appear before the IO, Your Lordship.
on the following conditions. The applicant accused shall appear before the investigating officer within 7 days from today. Then the normal those
Yes, sir.
normal 3 grounds. You just write. List after
On 13th, Your Lordship.
13
Obliged.
or after 2 weeks.
Your Lordship, it's up to Your Lordship, Your Lordship.
No, when do you want?
Your Lordship, 13th
13
is your next week. It's
One
1 week.
week.
Yeah, 1 week is
Okay.
enough, you know.
1306/2020.
Deeply obliged, Your Lordship.
It's a civil revision petition or what? Non-APS. Yes. Non-APS. We call list after 4 weeks.
Lordship, I am for the respondent number one.
Have you filed
No, I have not filed.
you are supposed to file some, huh?
Lordship, lower court record may be called for, because this is civil revision petition.
Who appears for the petitioner?
Petitioner was in virtual, that.
Virtual. Was
Now he is
asking
not-
for a time.
Yes.
Non-APS for the, non-APS for petition on call.
Lordship, may I pray that records may be called for?
Mr. R. Koi, learned counsel for respondent
Respondent.
is present. Call for the trial court record. List after 4 weeks.
Much.
Dismissed.
No, Lordship. My friends of time.
Why?
No, Your
Want to
Honor.
dismiss the-
As, as per instruction from my senior Mr. B. Taipode, we have already filed our counter affidavit day before yesterday. So this matter may be listed for hearing you.
What is there?
Lordship, status of the case, Lordship.
Not status. What is the case?
Lordship, land compensation issue, Lordship. Land compensation issue, Lordship. Land compensation is well deciding the land compensation, Lordship. Title is given to the private respondent, Lordship.
So you file a title suit?
No, Lordship, here, Lordship, is passing the award, Lordship. Land compensation award, Lordship.
See, you have claimed ownership of that land
Yes, Lordship.
and proceedings was initiated
Initiated, Lordship.
before KEBA,
No, cover, Lordship.
additional deputy
Yes,
commissioner.
Lordship.
And then additional deputy commissioner filed decides against you
Yes, Lordship.
and you file an appeal,
Yes, Lordship.
which is not maintainable. You cannot file an appeal
Uh,
against the order of the additional deputy commissioner before the deputy commissioner.
Yes, Lordship.
So you are the one who has claim for title or ownership or title of the land and initiate the process, obviously the authority will decide what's wrong.
No, Lordship.
What is the wrong?
Lordship, while issuing land compensation.
Is it by the, initiated by the respondent?
Yes, Lordship, respondent, Lordship.
No, who has filed a complaint or whatever?
Lordship, not complaint, Lordship, exactly, Lordship, land compensation issue, Lordship.
Yes.
Well, land compensation was given, Lordship. Call for the land compensation, but Lordship, claim in objection, Lordship. My claim was rejected by the respondent authority, Lordships. And given the land compensation,
By which letter or application or petition you have initiated before the additional deputy commissioner?
Lordship. Chairman. Annex, additional deputy commissioner order is page Lordship 30, Lordship. Order passed by additional deputy commissioner, Lordship. Page 30, Lordship. Page 30, Lordship.
30.
Yes, Lordship. 30, Lordship. Lordship, type copy is at page 33, Lordship.
Where is the finding, final finding?
Final finding, Lordship. Page 35, Lordship.
Yes, you read it.
Well, Lord, we'll kindly fix this matter for some other day.
I just wanted to know.
Just whether
He said,
Rentu requested.
they-
Well, Lord, it is the fact, if I understand, let me articulate in
no,
2
I
minutes.
understood, I understood. Just wait. Just let him read.
Okay.
Let me have the privilege of hearing him.
Lordship, this matter, Lordship. I'm not prepared, Lordship. Exactly, Lordship. This matter, Lordship.
What do you want?
After 2 weeks.
On the joint prayer of learned counsel for the parties, Mr. G. Bam for the petitioner and Mr. I. Bam. More Bams.
Yes.
Bam brothers. For respondent.
Yes.
List this matter after 4 weeks or 2 weeks. 2 weeks.
Offline.
May I please?
Yes.
Here in this case,
Without jurisdiction,
my lord.
heard Mr. K. Tama, learned counsel for the appellant. This is the application, appeal against the, what is that? Where is that impugn order?
At page 21.
20?
Dated 29,
No, where it is?
page 21 to 30, ma'am.
21.
21, ma'am.
So what is it? No application. This is an appeal. Against the judgment and order. Is it judgment and order?
This should be order, my lord.
Against
In
order,
past I.
order dated 29/02/2024. Passed in IA number 46 of 2023 in title suit number 19 of 2023 by the Civil Judge Senior Division.
0, my lord.
Senior Division 0.
My lord.
What is that? What is the order?
Whereby, my lord, kindly come to page 30.
Ah.
Whereby, my lord, the order issued
Whereby the order dated 2011/2023, right?
my lord.
It made absolute and to be continued till the final disposal of the case. Title is there. Title suit is there
Title suit is pending, dear man.
on the ground of what is the ground?
Ground not mentioned, my lord.
Hmm?
Ground not mentioned.
No, your ground.
My ground, my lord, basically there was a jurisdictional error. Yes, because in the presence of when the
On the ground of jurisdictional error, in associates the learned civil judge senior division 0 has no jurisdiction
to entertain that title suit
to entertain the title suit as well as pass the impugn order.
arbitrarily, my lord.
List of issue notice returnable by 3 weeks.
Since my lord, impugn order is without authority, this may be suspended.
Yes, how many respondents?
Total, my lord, 18 respondents, my lord. 19 respondents. my lord.
Petitioners to take steps for service of notice upon the respondent number 1 to
19, my lord.
19, 1 to 19 by registered post with AG within 7 days
My lord.
from today. In the interim, it is provided that the impugn order dated 29
29 February 2024.
29/02/2024
29 February 2024, my lord.
Shall what was the order there? What is to be
That is
what
kind
has
of
been made
positive
absolute?
injunction, my lord. What happened actually, this is about election of Karadadi district student union. Wherein, my lord, without there being any election, this respondent number 1, 2, and 3, they have been declared unopposed by manipulating entire
In that
process.
case, we'll just say shall remain state.
Shall remains.
Yes, till the returnable date.
Right.
Next para. It is provided that since the interim order has been passed without hearing the respondents, the respondents may file appropriate application for modification applications and so on of the present of this order, if so advised. This up to 3 weeks.
Please, my lord.
Yes.
My lord, this item number 13 is filed by the respondent, but since the petition is ready to dispose of, actions of pleading has already been completed. So, my lord, this matter may be disposed of today, my lord, by taking out the item number 14, my lord, main case. Because so far the item number 13 is concerned, this is only the application trying to vacate the interim order passed earlier by this honorable court. So now stage is in the final stage to dispose of the matter. My lord, the case before the lordship is the impugn order passed by the ADC.
Are you ready?
ADC Nari on 18/9/2023, whereby, my lord, I have been directed to remove my private gate,
Yes.
which has been constructed over the, my lord, my approach way to my residence. And that impugn order has been, by the impugn order, I have been directed to, my lord, vacate within the 15 days. So, my lord, this impugn order was passed on the basis of the complaint submitted by the respondent without, my lord, hearing to me, without hearing and without show cause notice as to why, my lord, I should be evicted. But the final order was passed. I will be evicted from the, my gate should be removed within 15 days. Now I will take the lordship to the facts of the case. What had happened about the facts? In fact, my lord, in this case, we are the neighbors. We have been living together in the same area at the Nari. It was in the years 2019 that my approach road was blocked. My approach road from main road to my house was blocked by the respondent. Therefore, my lord, I called a meeting, and accordingly the KEBA was conducted, and thereby the KEBA has decided that there was a existence of the approach road. Therefore, respondent was directed to vacate the portion of the road which she has blocked. That was the decision of the KEBA order, which was passed on 15/6/2019. Now, the burden lies to the respondent to appeal against the KEBA, and accordingly that she prepared the appeal against the KEBA before the deputy commissioner. But the deputy commissioner of the concerned area could not accept on the ground that till the time the power of the deputy commissioner were already been taken back. Therefore, the respondent number one, as an appellant, she was directed to approach for the continue for the further forum. But, my lord, despite of continuing her appeal process, she had constructed the RCC wall over the disputed gate. Therefore, my lord, I approached before the concerned ADC Nari for the execution of the KEBA decision. In the meantime, the ADC Nari has passed that the KEBA which was passed in 2019 should be re-verified by calling all the KEBA members. And this order was passed by the ADC Nari on 22 March 2021. Therefore, my lord, I came before this honorable court by the CRP number 18 of 2021. Thereby, my lord, this honorable court has set aside the order passed by the additional deputy commissioner that since the KEBA was already finalized, KEBA has already attained its finality. Therefore, this cannot be
this cannot be taken press hearing. And accordingly, I was directed to my lord appear with for execution. And accordingly, the execution petition was filed. Despite of the High Court's order in the execution petition, my lord, what had happened, my lord, the ADC Nari has called all the entire members who has participated in the KEBA, my lord, to ascertain that because, my lord, so far the KEBA decision is concerned, one point, particularly clause 3 of the KEBA decision was unambiguous, my lord, ambiguous. It carries double meaning. Whereas my contention is that so far the KEBA decision is concerned, you have to open the gate. But what her contention is that if gate is to be open, both the gates should be open. By taking pretext of this, my lord, misunderstanding, now in the execution, the ADC Nari has clarified all the person who were attended the KEBA and thereby confirmed that yes, it was confirmed the person who should remove the gate is respondent, my lord, not to me. Now, because, my lord, that approach road was only for my purpose, my lord. Now, my lord, thereafter, the execution was, my lord, completed. The KEBA order which was passed on 15/6/2019 and the execution was completed on 26/2023, whereby, my lord, the respondent was asked the gate RCC, my lord, RCC gate constructed, RCC wall, not gate, my lord, constructed by the respondent was dismantled and thereby I was allowed to approach that road. Now, undisputedly, my lord, after passing of the execution, that approach road belonged to me. I have returned back to the approach road, which was exist earlier, even before she established to that area. Therefore, my lord, in view of dismantling the wall, blocking my way, now there is this approach, my approach route remain, my lord, open. As a result, there is my lord, entry of the stress of, my lord, stray animals. Accordingly, my lord, I have constructed the gate to that particular area because that area is no more disputed area.
No, but then it blocks the other person. the
No, man.
respondents.
No, man. Now, exactly, my lord, what respondent
It's
has,
a pathway.
what the respondent has, my lord, projected that it has blocked the other person. There is, my lord, no other person, my lord. By this, my lord,
Even if no other person, if it's blocked the respondent, you will have to open it. That's all.
no, my lord. The dispute was between whether that exists, that who shall block, who shall open the gate. And for that purpose, my lord, that has already been decided.
This has been decided and they have demolished the structure.
Demolished.
Now
And-
you have constructed.
And
They have been allowed to demolish because it's obstruct. Now you cannot obstruct them also.
my lord, but that was only for my purpose. That is only for my approach road. No
what,
other
What
person.
about her approach road?
My lord, she has many approach road. Her road, her lane is
But
just
then
with the,
we don't know. But then additional deputy commerce finding is that it obstruct the pathway.
that's, my lord, I am trying to demonstrate that was, my lord,
How do we
completely
decide that?
wrong.
You tell us if you may be the respondent has been asked to demolish that, remove that structure that which you have done,
No.
which she has constructed,
No.
which was, obstructing you.
Exactly,
Right.
my lord.
Now it's free.
No, it is free and
No, you cannot obstruct her again.
No,
by
my lord.
constructing another gate. That is what they are saying.
that has,
That is the finding of the deputy commissioner.
that what,
the
my lord,
additional
I am
deputy
trying to say that is the wrong
You
presumption
also removed your gate.
constructed by them. my lord.
You removed your gate also. What is the ground of challenge?
So far, the my lord ground is concerned, my lord.
We'll see.
If, my lord, let us assume that, my lord, if,
Heard somebody learned counsel for the petitioner and also had
my lord, I may be allowed to complain, my lord.
what complaint? You are
My lord.
agreed by the notice of the ADC.
My lord, notice of the ADC,
to remove your the gate.
my lord.
Yes.
Therefore,
We'll
therefore, my
affirm-
lord, this should,
We'll affirm this. We'll affirm this.
my
There's
my
no
lord,
wrong.
my lord, this need to be, my lord, stayed, my lord. This need to be set aside, my lord.
No, will not.
And even if it is also, my lord,
You will have to. You will have to. It's remove the gate. It's
If-
obstructing other.
my lord, if I am to be removed also, my lord, it was the duty of the deputy, additional deputy commissioner to, my lord, inform me by, my lord, showing,
Notice has been
show cause
given.
notice, my lord.
You file an application. It's a notice only.
No, my lord. This is direction that I should vacate within the 15 days.
So we'll give you.
No, my contention is, my lord.
We'll give you another 20 days. You remove it.
No, my lord. My contention is, my lord.
Then,
Ah.
then you whatever you want to. We're dismissing your this revision petition.
Ma-
Your only contention is that you have the case was in your favor. It has been executed,
Executed.
right?
And
In that case, where she has constructed wall.
dismantle
it
wall
was
who is
dismantled.
blocking my way.
Okay.
And
So
now
you-
I am using that particular way.
It was in your favor. Now you want to. You have constructed a gate.
Get for safety of my house,
Yes.
my lord. And there is no other, my
So
lord.
it obstruct her.
No, my lord. This is completely the
So
wrong
you
concept.
go back to deputy commissioner. Will affirm this.
My lord, this can be, my lord, sent back to the deputy commissioner to at least to hurt me, my lord. If my gate is to be removed, my lord, I should be hurt. But no notice has been, my lord, no, at least show cause notice has been
Now,
issued. my lord.
how can just because you have you have got it the wall which has been constructed by the respondent to got it removed.
My lord,
You don't have a license to construct the gate
but my lord,
which obstructs the other persons.
what, my lord, my humble understanding, my lord, execution mean, my lord, the decision has passed. Kheba has decided in my favor. Therefore, my lord, undisputedly, the disputed area
That's not
become
the
my
issue now.
area
Issue is you have constructed the gate.
to my private land, on my private land, my lord, to protection of my house.
It's a village.
It's village, but it is village area, but no one is used. I am only the person who use. But what the respondent is, my lord, saying that I am obstructing to the village. How, my lord? She had constructed the permanent wall since 2021 until 2023. And no person
That has
was
been
there,
removed.
except my,
That has been dismantled and removed.
that has
Why
been
not?
removed. So, my lord, that
The
area
matter
is,
is there.
that approach area is only belong to
To
me.
that
my-
extent, you are right. Now you are wrong.
my lord,
Yes.
if, my lord,
Lordship, exactly, these has to be read conjointly because the execution order, in the execution order passed by the ADC Nari, it is very clearly, may I read
Where it is?
page number 24,
24.
24 of my affidavit.
in fact, my lord, so far, since the matter is going to be disposed of, my lord, so
Yes.
far my submission is, my lord, I am just based on the brief, but lord, I am yet to go through to show this honorable court to the record, my lord. What is there exactly?
This
Because,
is civil division. I will not
Lordship,
go
may-
into that.
to my humble understanding, all the merits has been gone. Execution order has been passed.
And the impugn order is the continuation of the execution petition, execution order passed in execution petition,
Where
not
it
the
is?
new one. It is page number 24, down below, in view of,
24, in the IA,
no, in the main counter affidavit filed by me.
counter affidavit, where it is? Yes,
Page number 24. In view of the above, as the disputed matter comes under Nari circle, the executive magistrate EAC CO of ADC Nari is hereby directed to dismantle erected wall obstruction whatsoever be of the Srimati Jumbam Puyu to pave the way for motorable path of at least 6 feet wide. Therefore, this impugn order is continuation of this execution petition. Therefore, so cause notice is also not required because she has violated this order by constructing after my demolition, after I dismantled my boundary wall, she again constructed in the same place, violating this execution order. Now, page number 28, the impugn order. Page number 28 is, may I read? It has been brought to the notice of the undersigned that you have erected an unauthorized iron gate obstructing a pathway at Nari village, whereas the same pathway was opened on 15/7/2023 by dismantling the earlier obstructing structure in accordance with the order passed by the Honorable Court of Additional Deputy Commissioner Nari Lower Siang District Nari Execution. This Yahya Bomjen versus Srimati. Such obstruction of pathway is not only a nuisance but can lead to breach of peace and tranquility. This is the continuation of that order. After execution of the order passed in execution petition, she has again violated that order. So, without going into the merit, there was series of litigation earlier. Finally, this execution petition order was issued by the ADC Nari. Everything was all right. I was using the road, a pathway. Suddenly, she constructed the iron gate wherein she has written resident of Gibom Bomjen, her father's name. Whereas the iron gate where she has erected is 300 or 400 meters away from her premises. It is just adjacent to my premise. So
it's her land.
It's not her land. Just page number 17. Page number 17. I just wanted to show you how this is not land. Title of the land was never disputed in entire series of the litigation. It is my land. Lordship, this is page number 17 is the type copy issued by her, the father of the petitioner. This is to certify that the land measuring this is as per boundary described: north lane of Kribom River, south lane of Tai Gamlin, east lane of Gitum Bomjen, west forest step and office.
You have also obstructed her.
Earlier, because these
that has been culminated into this execution.
Exactly. I'm not
so
disputed.
You have removed everything.
Yes.
Now she has constructed.
She has constructed
iron gate.
Iron gate, wherein she locked the iron gate even.
Which obstruct your
yes
movement.
Yes. The decision or the order cannot be.
Yes.
My lord, still I am to answer, my lord, 2-3 line.
What 2-3 line? You tell us why, how this is wrong. If you know that. That's all.
Exactly, my lord. Since the execution was, my lord, complied, meaning thereby, my lord, whatever the disputed at that area has already been decided in my favor.
Yes.
And
that doesn't mean that you have a license to erect
my lord, that is
iron gate obstructing others.
No, that is completely my lord, misleading to the court. No other one is there. And one thing, my lord, what they are saying that 3 to 200 meters away. So far, I know my land is, my lord, within 64 kilometers, or 64 meters. And now what was
Forget it. What is
exactly, my lord, what was
the
the,
ground of your challenge here? Ground of challenge.
yes, my lord, the grounds of challenges, my lord. The disputed area is completely under my possession, is my road. That has been decided. So it's up to me to lock or, my lord, not to lock. He should not be.
Even if the ground will reject it. Dismissed. Heard Mr.
Because, my lord,
C. Modi, learned counsel for the petitioner. And also heard Mr. R. Koi for respondent, sole respondent, learned counsel for the respondent. Yes. Anything else?
my lord,
By filing this civil revision petition, the petitioner has put to challenge the notice, page 4, what is that? It's page 41. Notice dated 18/09/2023, passed by the Additional Deputy Commissioner, Nari, Lower Siang District, whereby the petitioner is directed to remove the gate and any other associated structures constructed by the petitioner within 15 days from the date of the notice, on the ground that it obstructs the pathway of, and it's not only an obstruction of pathway, but also a nuisance which may lead to breach of peace and tranquility in the area. Next para. The case projected, the case of the petitioner, sort of unnecessary details, is that a land dispute has arisen between the petitioner and the respondent, which has been finally settled list of, what is that execution?
my lord, in education in page number 39.
39.
38, 39.
It starts from 38 to 39.
39, yes. Next para. After the, the matter was settled by a Keba decision dated 15/06/2019. It is the, what was the, before this court, what was the challenge?
Before this court, the challenge was order passed by the ADC for re-inquiry of the Keba.
Okay. Keba of 2019.
2019.
Okay. Next para. The petitioner had approached this court by filing a civil revision petition being CRP 8 of 2021, whereby against the decision of the Additional Deputy Commissioner Nari dated 22/03/2021, whereby the Additional Deputy Commissioner has, what was his decision?
That was decided to re-inquire the matter, directing the
This additional deputy commissioner has decided to
re-inquire the matter by directing the
revisit the Keba decision dated 15/6/2019. Mr. This court by order dated
19/10/22.
12/8/2022.
That's my.
12/08/2022. States that the order of the additional deputy commissioner dated 22/03/2021. And a liberty was granted to the parties to approach appropriate forum under appropriate provision of law for execution of the Keba decision dated 15/06/2019. Next one. Pursuant thereto, the petitioner has approached the additional deputy commissioner, Dari, for execution of the Keba decision dated 15/06/2019. Next page. The additional deputy commissioner, Nari, by order dated 20/06/2023, in the execution petition, execution proceedings, has directed the respondent
Yes, respondent.
to dismantle the erected wall obstruction whatsoever to pave way for motorable path of at least 6 feet wide. Accordingly, the erected wall was removed, was removed by the respondent
By official staff, my lord.
Huh?
By official staff.
I have removed in presence of officials.
Okay. Anyway, it was removed. Accordingly, it was complied and removed. The erected wall was removed. Christoph. Next para. By notice dated by the impugn notice dated 18/09/2023. The additional deputy commissioner Nari has directed the petitioner to remove the gate and any other associated structure as it has caused obstruction of pathway It is also the deputy commissioner has clearly intimated that the pathway was opened on 15/07/2023 by dismantling the earlier obstructing structure in accordance to the order passed in the execution case list of being agreed from the impugn notice that it so and so this present revision petition has been filed. Next para. Mr. C. Modi, that is counsel for the petitioner, submits that since the Keba decision, Keba has decided in favor of the petitioner with regard to the dispute between the petitioner and respondent. And pursuant thereto, an execution has been, the execution order has been passed for removing the dismantle the wall erected by the respondent, comma, the petitioner has the right to construct a gate, whatever, whatsoever, or any structure within the premise, within her premises. Christoph. He submits that the respondent has no authority, has no right to claim or make any complaint against the petitioner, as the erected gate is within the premises of the petitioner, and it does not cause any obstruction to the petitioner or any it doesn't cause any obstruction to, it doesn't cause obstruction to any pathway. Christoph. Therefore, he submits that the issuance of notice against the petitioner for removal of the gate constructed by her is illegal and be set aside. Next paragraph. On the other hand, Mr. Arko, counsel for the respondents, submits that the impugn notice has been issued as the petitioner has illegally constructed a gate obstructing the pathway of the petitioner, taking advantage of the execution, taking advantage of the execution order whereby the respondent was directed to dismantle the erected wall. He submits that the gate constructed by petitioner is 400 meters.
No, not exactly 100.
200
to 300.
200 to 300 meters away from the premises of the petitioner, and it is adjacent to the house of the
Respondent.
petitioner, which caused obstruction to the petitioner.
No, respondent.
To the respondent. Therefore, the addition deputy commissioner has rightly issued a notice for this removal of the gate constructed by the petitioner. Next paragraph. I have considered the submissions of the learned counsel for the petitioner and also perused the materials available in the court. Come on. Please, next paragraph. On consideration of the submission as well as the materials, come on. It transpires that the dispute with regard to the boundary wall,
Pathway.
Approach road.
Yes. It's not approach road.
It's pathway.
Yes, pathway. Clearly written pathway.
Exactly.
Same meaning.
Dispute with regard to the pathway has been resolved between the petitioner and respondent has been resolved by virtue of resolved pursuant to the direction for dismantling the erected wall by the respondent. Dismantling the erected wall of the respondent, which was causing inconvenience and obstruction to the petitioner. List of. It is also seen that an information has been brought to the notice of the additional deputy commissioner that the petitioner has erected an unauthorized iron gate obstructing the pathway at Nari village. Full stop. It is also stated that the same pathway was opened on 15/07/2023 by dismantling the earlier obstructing structure pursuant to the order of the additional deputy commissioner in Nari execution case number 1 of 2021. In between the petitioner and the respondent. On having been intimated and informed about the said construction case and erection of gate which obstructs the pathway at Nari village, the impugned notice has been issued directing the petitioner to remove the iron gate and any other associated structure within 15 days. On careful perusal of the notice, the petitioner appears to have erected an iron gate which obstructs the pathway of Nari village, which cannot be permitted. List of. The petitioner has been given an opportunity of 15 days, which is a reasonable time. List of. It cannot be countenanced that just merely the earlier dispute of obstruction to the petitioner has been decided and settled in favor of the petitioner, maybe against the respondent. The petition would not have any license to construct or erect beyond his premises, which cause an obstruction to the pathway at Nari in the village. The learned counsel for the petitioner, apart from such submission, has no other grounds to has not made any other grounds challenging the impugned notice that is so and so. Having considered the in view of the above, in view of the discussion made here in above, this court, in my considered view, no ground has been made out by the petitioner for interference in the similar, for interference to the if you notice that at 18/09/2023 was by the Additional Deputy Commissioner for into in this revision petition. Accordingly, revision petition stands dismissed.
My lord, one line, my lord.
The Additional Deputy Commissioners is directed to ensure that no one should obstruct, no one should erect any structure, either gate or wall, which obstructs the pathway of the village in the people in the village of Narikoi, of Nari.
Now, my lord,
Interim.
one line of my submission has been missed out, my lord, so that may be added, my lord. What my submission is, my lord, the gate which I have constructed has not obstructed to any villager, my lord. That line may be added, my
Just
lord.
add that.
That is my lord, my prime
The
submission.
gate which Mr. Modi submits that, it's somewhere there. Further submits that the gate which the petitioner has erected does not obstruct in any manner to anybody in the village. That's all. In view of the order, so disposal of the main petition, I stand. Close and dispose.
Item number 15.
May I please, Lordship? I am appearing through video conferencing, Lordship.
Yes.
Lordship, this is a GST matter. If your Lordship can recall, in April first week, your Lordship had taken a matter before Itanagar bench, wherein the wires of section 16(4) was challenged, along with the notification by which extension of time was granted for completing assessments.
Yes.
Lordship had issued notice and granted interim protection to the petitioners. The petitioner was Lordship Sushi Arunachal Highways. The WPC number was Lordship 152/24. Similarly, Lordship, in this petition before this court today, I am challenging the show cause notice and the order, which are based on the same notification, number 9/23, by which the GST authorities had extended the time limit for completion of assessment under section 73, Lordship. A similar order passed by the principal bench has been annexed by me, Lordship, which is at page 81 of my petition, Lordship.
Page 81.
Page 81, Lordship.
Yes.
The notifications has already been challenged, which is being examined by this court, Lordship. So if similar order is passed, I don't think that my learned friend will have any objection, Lordship. In this similar order, Lordship, perhaps the paragraph 4 will not be required because that is related to state GST cases. This is a central GST case, Lordship. And paragraph 7 mentions the order date, Lordship. Order date in my case is 22/4/24, Lordship.
When this matter is listed next,
Lordship.
when the other matter is listed,
in Itanagar, I would not know, Lordship, but in principal bench, these matters are listed in 12th and 13th of June, Lordship.
12/6.
Lordship. These matters are pending all throughout the country, Lordship. In several high courts, the matters are being examined. Punjab, Haryana High Court, Gujarat High Court, Telangana High Court, AP High Court, Rajasthan High Court. Everywhere it is pending, wherein interim protection has been granted, Lordship.
Yes, where is Mr. Kato?
Lordship, the senior counsel is just now leave the court premises due to some personal difficulty. So as per the instruction seek from the respondent, we have no objection regarding if the same order is passed as far as annexer in
Page 82, 81.
81. We have no objection.
Notice has been issued.
Lordship. And
Notice
since
has-
order has been passed, Lordship, it has been directed that the recovery shall not be enforced during the pendency until further orders, Lordship.
So yesterday notice was issued.
No, Lordship, notice was not issued. He submitted that he needed instructions. The matter should have been listed for motion today, but I suppose due to inadvertence, it got listed in admission column, Lordship.
This is what this is what I wonder. Heard Mr.
D. Saraf, Lordship.
D.
D. Devendra,
Delhi.
Delhi.
D.
Lordship.
Saraf, learned counsel for the petitioner. Also heard Mr.
M. Tanga.
Huh?
M. Tanga.
M. Tanga, learned counsel appearing on behalf of Mr. M. Kato, learned GAGA. For respondents. Next para. Challenges next para. But in this writ petition is to the notification number 09 of 2013. The central text dated 31/03/2023 and notification number 56 of 2023. That's city dated 28. It's page 32. 28/12/2023 being ultra-virus the provisions of section 168 capital A of GST, CGST oblique AGST Act 2007. And also to the so-called notice dated 21/12/2023 and order dated 22/04/2024 issued by the
Issued by the CGST operative, Lordship. Assistant Commissioner CGST, Lordship.
Respondent number
4.
Superintendent, the superintendent within bracket anti-evasion, Office of the Commissioner GST and CX, Itanagar, Arunachal Pradesh. Issue notice returnable by 4 weeks. 3 weeks or 4 weeks?
Lordship, 4 weeks.
4 weeks. Considering that the cardinal bench of this court by the order dated 02/04/2024 has passed an interim order in writ petition number 1764 of 2024. and that the learned counsel for the respondents on instruction raises no objection to such the proposed interim has raised no objection to the objection and granting relief as spread by the petitioner, comma. Till the further order till the returnable date, comma. The recovery of amount assessed, is it so? Recovery of the amount assessed against the petitioner shall not be enforced. Before that uses, since the learned counsel for the petitioners have entered appearance and accepted notice on behalf of all the response, no formal notice needed. Extra copies to ensure. You furnish the extra same similar order.
Yes, yes, Lordship.
This assess.
Lordship, SS is right.
Okay. List after 4 weeks.
Deeply obliged, Lordship.
Item number 16.
May I please, the Lordship? My Lord, due to unavoidable circumstances, my Lord, I have to appear before your Lordship in video conferencing, my Lord, from Guwahati, my Lord.
Yes.
May it please your Lordship. Lordship, in this matter, we had also filed an IA for vacating of the interim order, your Lordship.
Yes.
There was a in the entire CD, there was an the status of the IO was that he has not been cooperating since he has been given bail, your Lordship, and therefore we had filed an IA. Even on the last occasion when the IA was heard, your Lordship, there was a suggestion made to the accused to appear before the IO on 4th of June, your Lordship. However, till date, your Lordship, they have not appeared. Your Lordship will see on the 6th of March, they have been granted interim bail, your Lordship. Repeated notices under 61 as well as 91 has been issued, your Lordship. They have not been cooperating in the investigation.
My Lord, though, my Lord, there was not action to appear, my Lord. Even then, twice, my Lord, petitioners before your Lordship appeared before the investigating officer, my Lord. And in the meantime, matter is, my Lord, already amicably settled, my Lord. And today, informant is supposed to appear before your Lordship to apprise your Lordship that matter is amicably settled, my Lord. And,
Your Lordship, I'm appearing on behalf of informant, Your Lordship. And this morning I have filed a wakalatnama, Your Lordship. And Your Lordship, about the complainant and the respondent, petitioner, Your Lordship, amicably settled the matter, Your Lordship. So I have no objection regarding the grant of anticipatory bail, Your Lordship.
But this is how you have entered into a settlement. What is the offense?
My Lord, some amount was taken, my Lord.
Not some amount here. The allegation is an cheating of an amount of 2 crore rupees, your Lordship.
Okay.
As per the investigation, your Lordship, out of the 2
Who is
crore,
the
only
informant?
the informant, your Lordship, will
Likatabo.
Lordship will find the FIR at page number 14.
Why you have in that case unnecessarily the investigating authority to set into motion?
Your Lordship, because
How you have arrived into a settlement?
Your Lordship, at first the petitioner was not cooperating, but after some time they somehow managed to settle the matter. That's why, and he was compelled to do the settlement, Your Lordship.
You have settled it?
Yes, Your Lordship.
Your Lord,
We're not interested, not involved with the society at large.
in fact, Your Lordship, if there is any settlement whatsoever, Your Lordship, the settlement cannot be a ground for the bail, first of all, Your
Yes.
Lordship. The second part, Your Lordship, is that the investigation has already started as per the FIR, Your Lordship. They had not brought into record any kind of settlement till date, Your Lordship. From the date of March, Your Lordship will see on many occasions, the
My
court
lord,
has given.
it is settled principle of law, my lord, in this kind of cases, my lord, criminal cases is not maintainable, my lord. And
No,
another bail.
See, that is the reason bail was granted. It's a bail jurisdiction. You are supposed to appear and cooperate. You are supposed to cooperate with the investigation.
We are
You have
cooperating, but
not. You have not. Yes, you have not done so. You have not done that. Therefore, we are vacating the interim, and you have settled the matter. Whatever you want to do it.
My lord, there was, my lord, we are appearing, my lord, time to time, my lord, but with the, my lord, illegal, my lord, demand, my lord, IO is, my lord, time and again, my lord, harassing the petitioner, my lord. Matter is already amicably settled, my lord. This is a financial transaction, my lord, and this honorable court, my lord, granted, my lord, other accused petitioners, my lord, grant.
But Mr. So-and-so, learned counsel for the petitioner, list this matter after 4 days so as to enable MS, what's your name?
B. Mema.
B. Mema, learned counsel for the
Informal.
learned counsel who appears to assist the learned additional PP
Yes, sir.
to file appropriate affidavit regarding settlement. Can you do that? We'll just see. Let her file the affidavit.
Yes, Your Lordship. Even on the next day, Your Lordship, if there is any citation to that effect, Your Lordship, I'll bring because.
List the matter on 14/6.
Your Lordship, if Your Lordship picks the matter on 15th, Your Lordship.
15.
Yes.
15 is what?
Your Lordship, I'll be out of station on 13th. I'll be
Saturday.
back on.
15 is Saturday.
In that case, 17, Your Lordship. 17th, Your Lordship.
17 is working day here.
In that case,
17. Okay, after a week.
My lord, I am from Guwahati, my lord.
Let this matter be listed on 17/06/2024.
My lord, 17 part 18, my lord, 18.
18, no issue.
In that case, on 12th.
18. 12. 18.
I have no problem, my lord.
On 18th, Your Lordship.
18.
Well, kindly,
Your
my lord,
Grace.
kindly interim order may be continued.
In that case, you just say on the prayer of learned counsel for the heard Mr. So-and-so, huh? This lawyer, what's his name?
A.M. Borbuya, my lord.
It's there. On the prayer of Mr. So-and-so and MS So-and-so who appears to assist the additional PP, list this matter on 18/06/2024. Yes.
My lord, kindly interim order may be continued. My lord, interim order may be continued, my lord.
Sorry. You are not cooperating.
Last petition, your lordship has directed to produce the MLC note.
Oblige, my lord.
Yesterday, I have been informed that the complainant for the victim lordship is already released from the ICU and he is at home. One video clip has also sent me through their family.
Yes, my lord, that part I accepted that I have.
You also want to compromise?
Yes, release from the ICU, but
So you
still
want
I
to
am in
also
the.
compromise? To settle the matter?
No, still I am in that hospital. And my certificate has also come, my 40% of the body has been burned out of that incident.
So what is to be done?
Oh, my lord, at this stage so
It's
far,
been lordship, it's been 27 days, lordship, now, behind the bar, lordship. Strict condition may be imposed to the alleged accused person, lordship.
Yes.
As per the lordship, I have spoken to him, lordship. The victim statement, there need to be re-examined of the victim statement. That's why the investigation is still pending.
We'll provide that she should appear.
No, lordship, victim, victim, lordship, who is in the hospital, lordship.
Do we?
Re-examine, lordship.
No, as and when she is called for, she will appear before the IO.
No, not see, he, lordship, the who is admitted
We are not
for
concerned.
re-examine, lordship.
We'll provide the condition that the accused shall appear as and when called for by the IO. All right. What do you say?
my lord, I am objecting on the ground that so far my lord, the cardinal principles of the criminal law is concerned, my lord. This is the so far what the my lord offense has committed by the accused is, my lord, come within the exceptional case where the bail should not be granted.
Why?
Because, my lord, so far the record appeared that this is the confirmed case. She admitted that what had done. Therefore, my lord, there is a likely it is confirmed that she will be convicted. In such situation, every effort will be made from her for, my lord, every possibility effort will be done from the accused to, my lord, tempering and hampering of the evidence, my lord. And therefore, my lord, at least till the submission of the charge sheet, my lord, she deserves to be in jail, my lord.
The lordship, the investigation part is completed from the IO side. And section 302 of the CRPC says that the counsel for the complainant is supposed to assist to the PT lordship through the written submission.
No, I have allowed him to submit. So you also have an objection.
As per the lordship, yes,
Ah.
lordship, this CD lordship, the case is still under investigation. The charge sheet has not been filed yet. And the victim statement also been re-examined, lordship, after he's been released from the hospital.
I humbly prayed it, lordship, since I've been in jail for the last 27 days, lordship. Now I'm ready to cooperate with as your lordship has rightly pointed out, as and when the IO call, I'll appear before him, lordship.
Heard Mr. T. Garam, learned counsel for the petition, and also heard MS L. Hage, learned additional PP. For the state, assisted by Mr. C. Modi. For the victim.
For victim.
Victim. This is an application under section 439 of CRPC, 1973. For grant of post-arrest bail to the accused person, MS Yannick Baki, in connection with Papu Hills PS case number 24 of 2024 under section 326, 285, 286 of IPC, 1860. The case emanates from the written complaint that the written complaint filed by one Sri Hilang Raj. Hilang Raj is the victim.
Lordship, complaint in another.
Hilang Raj, the victim public complainant, that on 07/05/2024, the accused against the accused before the OCPS, before the officer in charge, police station, Hapapu Hills, alleging inter alia that the accused had attacked the victim at around 08:00 hours at NSNC rented apartment, Papu Des Ramanwana, Papuana, near August store. Three-way patrol and tried to burn him alive inside the bathroom while he was changing his clothes. Pursuant to the affair, a case has been registered, being Papu Hills PS case number 24 of 2024 under section so and so, same 326-285 Indian Penal Code. List of thereafter, the accused Srimati what?
Miss Yaning Baki.
Yaning Baki was arrested on 09/05/2024. And since then, she's in judicial custody. Judicial custody. How many days now?
27 days.
Huh?
27 days.
27 days. It is the case of the applicant that the accused and the victim involved, they were having an affair. Thereafter, the accused having come to the knowledge that the petitioner is a married man, has decided to step the relationship with the victim, informant. On 0605, it is contended that on 06/05/2024, at around 5:30 AM, the complainant came to the rented house of the accused. Despite her resistance, she forcefully entered her room. The informant forcefully entered her room and started to hurl abuses, which resultantly, both the accused and complainant got into a heated argument. Accordingly, fights between the accused and the complainant accordingly led to the fights between accused and the complainant. The accused was assaulting the complainant was assaulting the accused. No. Listen, the complainant punched and kicked the accused all over the body of the accused, and then even subsequently assaulted sexually upon the accused. Thereafter, the accused has tried to burn down the complainant's car with a petrol, and the complainant suddenly snatched the lighter from the accused, and resultantly complainant got burn injuries in his legs. Please do. Second FIR. No, it's his contention. It's his contention. Next para. Mr. T. Garam, learned counsel for the applicant, submits that the incident has occurred due to the relationship of love affair between the accused and the informant, which has traumatized the accused. Please stop. It was at the heat of the fight that the complainant got burned. Please stop. The accused is a graduate and is preparing for the civil service exams since 2019. Please stop. The allegations against the accused is false, as in the heat of the fight, the petition, while the complainant was trying to snatch the letter with the petrol bottle, accidentally it got burned to the complainant. Please stop. The petitioner has been, the accused was arrested on when?
On 9/5/2024.
9/5/2024. And since then, she is in judicial custody for nearly 27 days. For 27 days. Please stop. The Mr. T. Garib, learned counsel, submits that the accused has been cooperating with the investigation and already recorded her statement before the investigating officer. And there is no requirement of custodial interrogation. Christopher. Since the accused is a lady and a just graduate and preparing for civil service examination. If the petitioner, the accused is put behind the bars continuously, it will not only violate the personal liberty, but it will hamper the future, the career of the accused. He submits that the accused is ready to abide by any conditions that may be imposed this court, and there is no chance of jumping the bail if released on bail, as he's a local indigenous person of the state. Therefore, he submits that the accused may be released on bail. Then what is your submission? MSL Hage, learned counsel for the learned additional PP for the state, while referring to the case diary, submits that
It's still pending. As the lordship, the
submits that the accused has admitted that she had committed the crime under frustration.
and victim is still in hospital, lordship, and his statement should be re-examined, lordship.
The victim, public complainant, has got 40%
40%.
burn injuries, and is still in the hospital, admitted in the hospital, and required re-examination of the what?
No, re-examination of his statement, lordship.
Re-examination of the statement of the victim,
Lordship.
victim public complainant. Please stop.
The burn is lordship 40% versus mark burn, lordship.
According to 40% burn.
44. This is the
4% burn. You write that.
latest update of this.
She submits that The accused is not clearly cooperating with the investigation, since the vital evidences like petrol container and lighter is still not recovered from the place of occurrence. Huh? If she is released on bail, there is a chance of hamper and temper with the evidence and witness. Therefore, the case is of the offense is serious in nature, the accused is not entitled to be released on bail at this stage, Consider the submission of land counsel for the parties. And also, give me the CD.
What's it?
Where is the case diary? It is reveals from the case diary. It is reveals from the records that the not records. It reveals from the case diary that the victim is seriously injured. The victim is injured of having 42% burn injuries and is presently admitted in the hospital. It is also seen that the bottle used for carrying petrol could not be recovered till now, even after 27 days. It also indicates that the accused has stated to have thrown the bottle into the river. What is the update status?
The case that is lordship, this last status lordship, it the same as it is lordship.
Which one?
Lordship, lordship in the case that is lordship, yeah, lordship.
Last one.
Last is lordship.
Which one?
Lordship.
This is yesterday, day before yesterday's.
As per the IO lordship, status is same lordship. This investigation is pending for the re-examine of the victim lordship. And charge sheet has not been filed yet lordship. That's that much lordship.
Case diary was placed before this court on 23 last when was placed?
Lordship, 4/6, Lordship.
No, no. On 16/05/2024. No, no,
The last Lordship, 4/6, Lordship.
no, no, before that.
16/5 is the first day, Lordship. I think 13, Lordship, 13/5 first letter was listed.
On 17/05/2024, the learned additional PP was directed to produce place the up-to-date case diary on the next day. Accordingly, on '27/05, no, no, no. The state, the case diary dated along with the status report dated 23/05/24 was placed for this court on 04/06/2024. On perusal of the status report, the case diary, this court has observed that the investigating officer has stated that the investigation is still in the initial stage and has opposed the bail on the grounds that the release of the accused person at this stage would hamper the investigation. Mr. Considering the above, considering the state of the status report of the investigating officer, this court has further directed the learned counsel for the learned additional PP to obtain the instruction list of today. Though the case diary has been placed, but the same status, with the same status of, with the same status, which doesn't disclose any new development in the investigation, except that the victim is still admitted in the hospital and a normal with a normal with a regular grounds of opposing the bail, that the investigation is still in the initial stage, and if the accused is released on bail, there is a likelihood of hampering and tampering with the evidence and the witness. On next para, on consideration above, this court failed to understand that in a case like the present one, if after the arrest of the accused and if the investigation cannot progress by progress in 27 days after the arrest of the accused, comma, that too the accused has alleged to have admitted, comma, no further custodial inquiry appears to be required. On top of that, that apart, the accused is a young lady of which, what age?
24 years.
24 years.
Or 22 years.
22 years, who is stated to, who is a lady of 22 years of age claims to be under preparation for competitive examination. List of next paragraph. What is the last line? Yes. Next paragraph. I mean, where is the case there as well as considering that the accused was arrested on 09/05/2024. 09/05/2024. And it's been, and she's been, since then she's in the judicial custody for 27 days. And the comma, I'm of the considered view that, and considering and considering the nature of the case, though serious, comma, no custodial inquiry, interrogation is required, comma, I deem it appropriate to, I am of the considered view that the accused deserve to be admitted for bail, Accordingly, the accused, namely, what's her name?
Yaning Baki.
Yaning Baki. Be released on bail on furnishing what?
Condition lordship.
Furnishing a bail bond of
Condition.
10,000.
released on bail in connection with the so and so, huh? Connection with Papu Hill PS case number so and so. Under section on furnishing a bail bond of rupees 15,000.
This is with certain condition lordship.
Security of, with one security of like, one security of like amount. To the satisfaction of the, who will release it? CGM, UPR. Learned CGM, UPR. On the following conditions. What condition you want?
He may be appear whenever called for till completion of the investigation lordship.
The accused shall appear before the investigating authority, investigating officer, agent when called for. Then those two, three conditions. The accused shall not
Leave the jurisdiction.
induce whatever is there. Three conditions. Then you should not also leave without permission.
Lordship.
The accused shall not, then third, the accused shall not leave the jurisdiction of
Internal lordship.
No, internal law.
without the jurisdiction of the Papumpare district. She is from Papumpare?
No, she is from the Procedural.
Okay, Papumpare district, without the leave of the, without prior permission of the land judicial chief judicial magistrate, UPM. This is original. Send down the, send back the case diary.
Bibliography.
Right.
The inmate Takar Pagba has a history of substance abuse for which he was treated symptomatically in the health center district Julie. There is no specific history, measure illness and stable at the time of examination. You are perfect.
Here, my lord, nowadays, district jail is giving a restriction. So we family member could not visit immediately. So after arresting the accused, accused has called the father. So he's complaining, telling that twice.
It is examined. She's all completely perfect.
But
He
then,
was,
my lord, here accused person is languishing under judicial custody for more than
Yes.
71 days.
doesn't matter. You are involved in NDPS.
So he has already given his compassionate statement, 161 is CRPC.
You yourself is substance abuse.
No, actually, my lord, during this while
This is what? Huh?
This is lordship, actually, this is LCR report, but here only lordship, this protection and remand lordship, that's it lordship. Trial has not been begun yet lordship.
Charge sheet has been filed.
No, no lordship, no,
Huh?
not yet lordship.
Then charge sheet has not been filed.
No lordship.
his position, nothing was seized.
It's
Yes,
only, then in that case, we'll have to see the case diary.
No, case is there lordship.
Okay, then. What is the status of that?
Lordship, as per this lordship, this case diary, the
Directed furnish a report before this.
lordship, the FSR report is awaited lordship, and all the lordship accused statement, this accused statement has been recorded under 161. But charges had to be filed. And the lordship, main lordship, the culprit lordship, is still at large lordship. He is not is absconding lordship.
Last occasion, on your submission, the medical.
Yes, actually, accused
Your
person-
ailments is, they've examined it. You are perfectly all right.
And my lord, the case has already been under judicial custody for long 71 days. So already
What is the mandatory period?
No, mandatory, it is, now it is, 180 days, I think.
Then
But then,
we have to be sure why you are saying,
no.
why
my
you
lord-
think,
my
you
lord,
must be sure.
He has already given his
So-
statement, and moreover, President, Bellor, who is father, is working at BSNL office, Itanavar. So I'm ready to comply, whatever the investigation officer call, and moreover now,
What is this?
my lord,
I told him to
now I'm,
look at that report. Your ground was that you are having a serious ailment.
no,
And this court has directed to furnish the report.
This, accused person has made a complaint. Sometimes it's paining, no, due to twice, scrotum, operation was done.
No, that's why on your submission, this court has directed to place the report. This is the report.
No, it's true, but, we are not visiting the.
So what is your ground of bail?
My lord, we are not visiting the district there. So while
You visit and come back to
accused,
confirm that.
accused person has, made a complaint that, he's, getting, moreover, more to important that now his, now school is opening, so he have to go to school. So now he's, for his career maybe spoiled. So now 71 days, he's already under judicial custody. So he's ready to comply, whatever investigation. And once
NDPS, no bail.
161
We'll
statement
see.
already reported.
We'll see the FSL report.
And moreover, my lord, here, I'm from my position, nothing was seized. Of course, I was consumer. So this is the intermediate, but, my position, nothing was recovered from, this is the, whatever.
Recovered from where?
From one lady, with, I don't know, that, I know that lady, but I was, she asked me for help. So I took that lady and one boy who is accompanied with me. They asked me leave. So I do not know, with my position, nothing was seized.
But your substance abuse.
I don't know, and more to say that, here, as per, my lord, here, provision 21B, as per 21B, here it said that whoever in contravention of any provision of this act or any rule or order made condition of license granted thereunder, manufacturer. I'm not manufacturer. In my position, nothing was sealed, nothing was seized. I was not seller and purchaser, transporter. This condition was given. So, my lord, I'm innocent with this case. I'm ready to face for trial whenever the.
Submit more than that.
My lord, while considering the age factor, this, it is only 18 years age. Now schooling, now school has started. So while seeing the complex circumstances.
Below 18 years or 18 years?
18 years only.
Which class?
He is in class 10, I think. And father is working BSNO, he's ready to control.
What you are reading? Which provision?
This is 21B. 21-year punishment for contravention in relation to manufactured drugs and preparation. Here, my lord said that whoever in a contravention of any provision of this act or any rule or order made or condition of license granted there under manufacture, possesses, sales, purchases, transports, import, interstate, export, interstate, or uses any manufactured drugs or any preparation containing any manufactured drugs shall be punished.
27.
Yes, I'm.
29.
I used to consume but not selling and all.
You want reformation. You want to go to rehab.
Oh, I think I'm already been the judicial custody for more than 71 days. I think. that
So it is a ground?
27.
Is it a ground for release you on bail? You tell us the ground, we'll release you immediately.
Now school is
Will grant you.
school is opening, so I have to. My career may spoil.
Sorry.
My lord, kindly see the.
You, if you want to do some more research, we'll take it up after a week. If not, dismissed.
My lord, kindly may see the age of the young boy.
I've considered, I've seen it. No bail. If you want to try next week, we'll try it.
Maybe fix it next week.
But this court will remain there.
Maybe next week. So this matter will be extended for it's like 1 week.
Do some research. Appears that you are not prepared today.
I'm prepared, but my lord, here I'm local people. From
You are not submitting what this court wants to hear. Consider. On the prayer of Mr. T.D. Rigia, learned counsel for the applicant. List this matter after a week. We'll see. Case diary, retain the case diary. Or, no, please. Why interim bail by the Supreme Court, whatever Supreme? On the ground that the case is pending.
No, my lord.
No, that was informed.
Actually,
At the time of hearing,
that
the matter is the bail application pending before the Sessions Court.
That was
You
wrongly.
apply there.
That was wrongly informed by the state represented counsel.
Now she's
on
interim out of the bail.
She is in judicial custody, but on interim bail.
Interim bail where?
She's released, already released.
Released to where?
Released by CJM.
If it is released, why? Why 439?
Or they have to surrender first.
Yes.
No, man.
Condition precedent.
You are on interim bail.
Hello.
And reason was perhaps why you have been granted interim bail, because the bail application is pending before the Sessions Court.
That was not the reason.
Now let us see what is the reason of your. We can. Where is the Supreme Court?
Actually, what happened, my lord?
No, I have understood. And in fact, I may not.
Immediately after rejection of the.
I'm just taking it up because there are certain things also I would not like to take up this matter.
Page 57, my lord.
Yes.
The operating part.
Where is that? This court informed the board that the petitioner had already been arrested also in the.
Under the peculiar facts and circumstances of the case, we grant interim bail to the petitioner, which shall be effect for a period of 1 month from today.
Yes.
Let the petitioner be released on an interim bail forthwith on the usual term and condition to be declared by the concerned court.
Decided by concerned court.
Yes, we have been informed that the regular bail application of the petitioner is already pending before the Session Court. The same may be considered in accordance with law.
Yeah.
This has been indicated before
This
the
is the
Supreme Court.
reason. Otherwise, Honorable Supreme Court has granted you a bail.
My lord. Actually, the reason for granting bail, my lord.
Yes.
This was not that because the matter or any bail application it was pending before the session court. Actually, what happened? Immediately after rejection of that AB number 64, 2024 by order dated 29/4/2024 by this honorable court. So this applicant, she prepared criminal leave application before the honorable apex court. In the meantime, on 8, the IO of the case he went to Delhi and arrested this applicant. Thereafter, even in the arrest memo, the reason for arrest, it was.
Anyway, let us not go to all those things. I've read your petition.
Well,
All right. Yesterday evening, I've read it. The issue is when you are out on bail, whether interim or whatever, you're already out. How can the 439 will lie?
Definitely, my lord, because I am in still judicial custody.
No, your lordship. They have to first come into the custody of the court, your lordship. Surrender first.
It'll have to be theirs.
No,
go back and come.
Yes.
Go back and come back.
Yes, your lordship. Go back and come back.
You first go back, surrender and come back if you want to move this bail. Or else you approach the Honorable Supreme Court that these are the situation. Because see, next para, we have been informed.
In that case,
wrongly, maybe wrongly. It was not a fact. It was wrongly informed to the Supreme Court. You go back. Because this 439, I'm clear about it. And may not be have that much of unlike the
in that case, my lord, with some order, this may be disposed of with some
Let them approach the learned court below, your lordship.
That is what I'm suggesting.
But then my understanding, maybe I'm wrong. If a person is arrested and if he is released on interim bail, still he is in judicial custody.
That is the reason you approach the Sessions Court.
No, man. Therefore, the requirement of custody as far as Section 439 is concerned. Therefore, I have made application statement in my application also. Kindly see at page para 15, my lord. Very specifically, I have mentioned that the applicant begs to state that though the AB number 64/2024 was rejected by this honorable court, however, same would not cause any legal impediment to consider the instant regular bail application under Section 439 by this honorable court. The applicant is in judicial custody and only she is on interim bail, and therefore she can be deemed to be in custody for the requirement as prescribed under Section 439 CRPC. This is my understanding. Because had it been pre-arrest bail application, it would have been different. In this case, she was arrested and she was remanded to judicial custody. Then Honorable Apex Court has
Why don't you approach the Sessions Court?
My lord, there is no any bar as such under 439. Therefore, my lord, at least if on maintainability this has to be disposed of.
Yes, on maintainability, this may be disposed of, your lordship.
If your lordship's understanding is that
Your lordship, I will rely the judgment, your lord, on it, on maintainability, your lordship, regarding the custody, your lordship. This is reported in 2008, 3 SCC 222 of para 20, your lordship. May kindly come to paragraph 25, your lordship. May I read, your lordship? We also agree with the Mr. Arup Chaudhary submission that unless a person accused of an offense is in custody, he cannot move the court for bail under Section 439 of the Code, which provides for release on bail of any person accused of an offense in custody, emphasize supplied. The precondition, therefore, for applying the provision of Section 439 of the Code is that a person who is an accused must be in custody and his movement must have been restricted before he can move for bail. This aspect of matter has been considered in Niranjan Singh case, where it is held that a person can be stayed to be in judicial custody when he surrender before the court and submit to its direction, your lordship. So, before your lordship moving this bail application, the accused has to surrender before this court or the learned special court, your lordship, or the session court, where they are preferring the regular bail, your lordship. And your lordship, so far as the present case is concerned, your lordship, the same, your lordship, situation arises before the Kolkata High Court, your lordship, wherein the anticipatory bail has been granted for a stipulated period
And within that stipulated period, what recourse can be taken by the accused has been laid down by the full bench judge of the full bench court of the Kolkata High Court, Your Lordship. Just for the reference to this honorable court, Your Lordship. The same situation, Your Lordship. The conditional bail has been granted, Your Lordship. Your Lordship, it's reported in 2002 SCC online CAL 451 Kolkata High Court full bench judgment, Your Lordship. Your Lordship may kindly come to paragraph 44. May I read, Your Lordship? Let us summarize the position emerged from the above discussion. A. The only remedy available to the accused upon rejection of regular bail is to apply to the superior court for regular bail and not once again for anticipatory bail. This is not in this case. Accused who prepare an application for regular bail in compliance with the condition stipulated in the order of anticipatory bail and physically submit to jurisdiction an order of the court before which such application is filed, the application is required to be disposed of on merit. If the outer limit of the anticipatory bail has not expired and the accused has appeared in person and placed himself in the control of the court. C. If the application for regular bail is moved within the duration of anticipatory bail, but the passing of the order is delayed for any reason whatsoever, and it is likely to come after the expiry of the outer limit of the duration fixed by the order of anticipatory bail, the court hearing the regular bail application can always grant interim regular bail for limited duration till final order are passed by the court. D. If the application for regular bail is moved within the duration of anticipatory bail and the same is rejected, refused, but the outer limit prescribed by the order of anticipatory bail has not expired, then instead of taking the accused into custody, he may be allowed to move the superior court for bail within a specific period, namely the outer limit as specified in the order of the anticipatory bail. E. If the application for regular bail is moved after or the date as on which the application for regular bail is rejected, and in either case the outer limit prescribed by the order of anticipatory bail has expired, then in that event, on and from the date of expiry of the period fixed by the order of anticipatory bail, the accused must surrender and be in the custody of the court before the superior court can take up the consideration of the application for regular bail. So here also it says, Your Lordship, surrender, Your Lordship. Has to be appear before the court, Your Lordship. B is clearly says
My
physically
lord,
submit to the
kindly
jurisdiction.
taken note of only two words, my lord. In those judgment, it is repeatedly mentioned anticipatory bail. That is settled proposition of law. If suppose anticipatory bail it is rejected, then person has to be surrendered. But in this case, my lord, accused was arrested from Delhi. He was produced before the CGM. She was produced before the CGM. She was remanded to judicial custody. By considering the peculiar facts and circumstances of the case, Honorable Apex Court has granted interim bail. So therefore, to my humble understanding, she is in custody. And the requirement under Section 439 to exercise that jurisdiction by the Honorable High Court and Session Court is only that person has to be in custody. That, my lord, Sudeep Kumar Bapna's case also, my lord. What is custody that has been defined, my lord?
When is the interim bail expires?
17, my lord.
17th of this month.
List it on 17th.
Yes, that will be.
Maybe kindly matter may be considered and dispose of, my lord. Because tomorrow we may not get bail also. In that case, at least sometime.
You'll not get bail, but it's 439.
In that case, my lord, the matter may be disposed of today.
When?
So that at least today, my lord.
Today, list this matter before any other appointments without me.
In that case, particular date.
No, I cannot. It will not be listed before this match.
At least before 17, my lord.
No,
So
no,
that we can-
you move in, you may move.
Because
Any other
my lord,
match.
maybe I am wrong, but my understanding, my lord, siege in custody. And the requirement 439, my lord.
No, I cannot take up this matter. I'll not.
Uh, 12, my lord. 12 of this month.
They'll be listed next week.
In that case, my lord, before the other.
No, that's why I said any other appropriate way.
Okay, in that case, my lord, tomorrow. Monday, my lord.
If I cannot take it up, you make a mention. Right. There's a reason. Makes.
Hello,
This is subsequent bail application, my lord.
Yes.
Before going to the FIR content, my lord, I wanted to clear some point, my lord. My lord, all the sections are bailable, except 397 are not bailable.
Yes.
Yes, my lord. My lord, in this section 34 is not affected, my lord. Yes, my lord. My lord, the applicant only affects 325 section, my lord. Not in the 397, my lord. As per FIR, my lord.
It is subsequent bail application.
Yes,
On what ground? What is?
my ground is that he was not present in the place of occurrence, my lord.
Same thing. You have
Yes.
said the same thing last occasion.
Yes.
Is that it?
Yes, yes, this aspect has already been considered.
My lord, only 325 attract on me, my lord, not other sections, my lord. As per section, as per FIR copy.
That is, since this is a subsequent bail application.
Yes.
It's a subsequent bail application. Or in a different case.
Yes, my lord.
Same.
In the different case, my lord, already bail was granted, my lord. Yes, my lord.
And rejection was rejection by this court.
On the ground that he is a habitual offender, my lord.
Yes.
But that is not true, my lord.
So what is the subsequent bail application here? What is the ground of
My ground is changed, my lord.
change circumstances?
Yes, the session court matter was disposed of, my lord. On the ground that bail was granted, my lord. As that that case was arising out of land dispute, my lord, between two group of people, my lord. I have written in the paragraph 9, my lord, page number 7.
After the rejection of your bail?
Bail was granted, my lord. After
No, by this page 20, page 20.
Page 20. After rejection of the bail, my lord, the session court was granted bail, interim bail, absolute bail, my lord. After rejection of the bail, the session court granted bail, my lord.
Yes.
Yes, my lord.
Then
That, thereafter I filed this bail application before this honorable court. To
when you have already granted, why you are filing the bail application?
in
here?
different case, my lord.
No, after this is a case rejection of what? By this court. Page 20.
In the order copy, my lord, bail was rejected on
Tell
the
us
ground.
what is this?
Actually, your lordship, what has happened, there is two cases. The one Balijan PS case, even there the accused is found to be involved, and this is the subsequent one which is before, for which they are before this court. And that bail application, the present bail application, prior to this, your lordship, their bail was dismissed, your lordship, on the ground that she was found to be involved in the earlier offense and she is a habitual offender, because the present victim in this case was the complainant in that case, your lordship. And the CV also revealed the same, your lordship. Considering that aspect, his involvement, the court, this honorable court has rejected his bail. Now they have approached this court in the subsequent bail application. This is successive bail application, without there being change in any fact and situation, without there being any change in.
That's what I'm asking.
Yes, your lordship.
What is the change circumstances
Yes,
to
my lord. Paragraph
file a
9, my lord.
bail application
May peruse.
after the rejection?
Yes, my lord. May peruse page number 7, my lord. Page paragraph number 9.
Yes.
May I read, my lord? Did the applicant beg to submit mention that one anticipatory bail application filed before the learned court UPA, my lord, against the present
Paragraph 7 or 9.
paragraph 9,
Yes.
page number 7.
Where the applicant and are co-accused.
Yes, my lord.
Huh?
Where the applicant and other co-accused got absolute bail, order dated 02/05/2024, and in the said case, the applicant filed the counter FIR, stating that about 150 people had confined and assaulted the applicant party, and took the license gun from the applicant's party, and the informant himself is the one of the member comes under the 150 people assaulted. Some of them were hospitalized and some are grievously injured. It is to mention that the said case was out of land dispute between the local and the Chakma Haujun refugees of Arunachal Pradesh, where both sides have filed the FIR, and accordingly the case was registered as Balijan PS case number 18/2023 and the Balijan case number 2023, where all the accused from both sides has got the absolute bail order from the learned session court UPA on the same day, 02/05/2024. I have annexed the FR order copy, my lord, on page number 23, my lord.
What does it mean? You read page 21.
21, your lordship, yes.
The provision of law is laid down in subsection section 413 of CRPC is meant to be used in present scenario.
413(8), your lordship.
Yes, page 21. You read the last line.
The provision of law laid down in section 438 of the CRPC is actually, your lordship, this typographical perhaps error, not meant to be used in the present scenario. It can be inferred from the rejection order itself.
There's no change circumstances.
That will not amounting to change in
Or else
circumstances.
it will be placed before the same bench.
Yes, exactly. your lordship.
My lord, section only at 325, my lord.
No, how your bail has been rejected earlier?
Yes, my lord.
Because after you were released in another matter,
yes,
I mean granted bail,
interim
you have committed this on interim. You have committed the same offense.
My lord, that is not true, my lord. That is conducted FIR, my lord.
You tell us it's a subsequent bail application. What is this change circumstances?
Actually, my lord, in this case, my lord, he was not present in the place of occurrence, my lord.
It's not a change circumstances.
Yes, my lord. But that is true, my lord.
In that case, it will be placed before the
same bench.
Yes, sir. And otherwise, there is a notification also.
The notification is already is there.
Interim may be granted, my lord, so he can appear before the.
Your bail application is not maintainable. Where's the question of granting interim?
My lord, contents are changed, my lord, the effects are changed, my lord. As per.
Acquisition has to be changed.
Yeah,
Yes, my lord.
see, they when the bail was rejected or considered or rejected, there should be certain circumstances, right?
Yes.
Thereafter, subsequently, there must be change circumstances
Yes.
so that you can move the bail, successive bail application. That is the law.
Yes.
You are not able to show that. You are trying to show that it was a different case. This is another case.
My lord, on that basis, my lord, another case, my lord, the bail was rejected, my lord. This while.
Bail was not rejected. Well, you were granted in the anticipatory bail.
Yes.
I mean, the interim bail. You committed this crime in the present case. So that was the reason you appears to be involved. What is change circumstances?
Change circumstances is the interim bail was granted earlier was absolutely.
Mr. What is your name?
PK government.
PK Gord, learned counsel for the applicant.
My lord, I am ready to cooperate with the IO, my lord.
This is this application under 460. This is an application, successive bail application filed by the applicant accused under section 438 CRPC, 1970 for grant of privilege of pre-arrest bail to the applicant accused Sri Tamsi Nook in connection with violation PS case number 0.2024 under section 341, 397, 325, 427, 506 of IPC. After Mr.
My lord,
This court,
my lord, my permission may be reported, my lord. My lord, all sections are not attracted with the.
but only one is
Yes, my lord.
One is-
only one, sir.
it doesn't make a difference. Is it a change circumstances?
My lord. 324 is a
yeah.
bailable offense, my lord. 325.
This court, the applicant accused has approached this court in the earlier round of earlier the petition applicant accused has approached this court by filing a bail application being AB 38 of 2024 for grant of the privilege of pre-arrest bail to the accused applicant. Please stop. Next paragraph. On 11/03/2024, this court, after considering the submissions and the materials on the court, rejected the bail application, the applicant accused. Thereby, it is provided that the provision of law is laid down in section 438 of CRPC is not meant to be used in the present scenario. As the petitioner, well, released on interim bail in another case 18 of 2023 under section 120B 325, 425, 336, public 506 of public 34 of IPC, read with Arms Act, read with section 25 of the Arms Act. By filing this successive bail application, no change circumstances appears to have arisen. Mr. P.K. got learned counsel for the applicant accused on repeated repeated queries as to how the what is the ground of filing this present successive bail application, and ask him to show any change circumstances, he could not able to submit, he could not able to show any change circumstances except on submitting, repeatedly submitting that the accused, the case where the accused was released on interim bail was a different case, and the present one is other case where the petitioner is applicant is seeking pre-arrest bail. Come on, next paragraph. Mr. T. additional PP. Submits that since there is no change circumstances, the present bail application is not maintainable. Yes.
Interim was granted by the session court was absolute, my lord. That after I filed this bail application, my lord.
Huh?
Interim bail was granted by the session court was absolute after that, my lord. After that, I filed this bail application, my lord.
Successive.
Yes, my lord.
First this one or last one?
First that one.
That one.
Thereafter, in this court, my lord. After
After rejection of this your bail by this court.
Yes, my lord. The session court was granted bail.
Where it is?
I have annexed, my lord. Page number 23, my lord.
That is the other in other case, Your Lordship.
Both are connected matter. They are arising out of land dispute, my lord.
Having considered these submissions and the materials available in the record, I find that there is no change circumstances for which this bail application can be attempted. The learned counsel for the applicant, despite ample opportunity to place and make ample opportunity to show of and it turns change circumstances. He has failed, visibly failed to show any ground of filing this application as the same as a bail, successive bail application. Accordingly, the bail application stands dismissed on not being on maintainability, on not being maintainable in the present form.
Obliged.
My lord, then my lord, he may be surrendered, my lord, before he may be surrendered before the IO, my lord. He may be surrendered before the IO, my lord.
It is your liberty is always with you.
They may not. Police may not arrest you also.
Maybe granted, my lord, so he can be taken closure, my lord. Protection may be granted, my lord. So he cannot be tortured by the IO case, my lord.
This law is there. Very simple. I've been asking you to show any change circumstances so that we can entertain into the merit. You are not able to show. There is no change circumstances. If you have change circumstances. Do you understand?
Yes, madam. Yes, madam.
Are you getting, am I
Yes.
clear?
Yes, madam. I'm getting.
I'm sure. Are you sure?
Yes, madam.
Sure.
Yes.
How the bail, when the bail, successive bail application can be filed? Under what circumstances?
After the effect of the case has been changed.
Okay, thank you. Yes, yes, call it. No issues. It's not 550. 450. This code is up to 430, 445. 445. Here and there, 1 hour, 30 minutes. doesn't make
Your
sense.
Lordship.
Yes.
Here already interim has been granted by this honorable court. And according to the direction by this honorable court, the accused applicant have appeared before the Likavali police station.
Yes.
And given his statement. And this was a misunderstanding between two lovers. The accused is only age of 19 years, 8 months. And the
Yes.
complainant is of 23 years. Some misunderstanding crop up between the both. That complainant have doubted accused applicant that he's keeping some relationship with other girls, especially with by name one Miss.
You have the case there.
Yes.
So
Anything is there?
Nothing, Your Lordship. Even the investigation has almost completed. We have got the MLC report also, Your Lordship.
Yeah, nothing is there.
Nothing.
Heard Mr. Bhattacharjee,
Yes, Your Lordship.
learned counsel for the petitioner. Decision bail application under section. This is an application under section 438 of CRPC. Praying for grant of privilege of pre-arrest bail to the accused, applicant accused, in connection with Likavali PS case
09.
number 09 of 20 under section 354, 458, public 509 IPC. Where is the FIR?
It's number 11, Your Lordship.
FIR is at page number
11.
Page number 11.
An FIR was lodged. Where is it one Miss Luxum Carlo? Huh?
Luxum Carlo, informant. Yes.
She is the victim.
Yes, Your Lordship. Informant is also the victim.
On
23
23/04/2024,
way back filing.
which is reproduced here in below. Page 11, huh? You just reproduce it. The next paragraph, pursuant to the FIR, above FIR, the case was registered being Likavali PS case number 9 of 2022, 9 of 2024 under section so and so. The next one, apprehending arrest and the above report is the present application has been filed by the applicant accused. Mr. The on consideration of the submission, it appears that the allegations as arisen out of What is the reason of allegation?
Allegation was that, your lordship, that the informant distrust the accused applicant, that absence of her, he is keeping relationships with some other girls. That is the only reason. And if
Appears to be out of mistrust between the applicant and the informant. Mr. Due to certain mistrust, there appears to be a fight. There was a fight.
Yes, fight.
informant came to the house of accused,
Appears
there
to
was
be
pushing
a
police.
fight between them. Mr. Next para. This court on when it was, we'll make it absolute only. This court on
20th,
24
on 20th.
granted interim bail to the applicant accused. Mr. MS in London additional PP has produced the case there. Next para. On consideration on the appraisal of the case diary, come on. The
Your lordship, the applicant here is cooperating, your lordship. Also, the investigation is almost completed, your lordship. And the other is that both the victims and the accused statements prima facie clearly states that they have a relationship, and the only quarrel between them was because of some another person, your lordship.
In between, both the parents, family members are trying to reunite them. Negotiations are going on.
On the appraisal case that it transpired that the issue has been arisen out of misunderstanding and differences between the complainant and the applicant accused. List of MSTs in the London additional PP clearly submits that the accused applicant accused is cooperating with the investigation, and the investigation is almost completed.
Almost completed.
Mr. And you have appeared.
Yes, your lordship. As per the direction
Next
given
para.
by this honorable court, within 7
Pursuant
days.
to the order interim bail granted by this court, the petitioner has already appeared before the investigating authority officer and recorded his
Statement on
statement.
31st of May. 31st May,
31st/05/2024.
and recorded his statement.
Yes, absolutely, sir. Okay. Considering next para, considering about, I deem it appropriate to make the I deem it appropriate to grant bill to to extend to grant privilege of pre-arrest bill to the accused applicant, namely so and so. Accordingly, the bill, the accused applicant, namely Majum type that they shall be released. No, not released. We'll just make the absolute only.
Yes, your lordship.
Yes, your lordship.
Bail bond already
Accordingly,
he
the
executed.
bill, interim bail order that is 28/05/2024 granted to the petitioner. The applicant accused is made absolute with the same terms and conditions.
Deeply.
Well,
Deep.
within this. We'll finish it, accept the hearing.
Please, my lord. My lord, I have before the lordship is pertaining to the condemnation of 108 days
Yes.
while preparing the appeal against the order passed by the deputy commissioner on 30/5/2023, ma'am.
Who has to file rejoinder?
My lord, that I have already received it.
Rejoinder you have filed.
No, madam.
You are supposed to file rejoinder.
No, madam.
Who has to file it?
My lord, in case of.
You are for the petitioner.
My lord, I'm
You are
for the
supposed to
petitioner. I'm the applicant, and if rejoinder is to be filed, my lord, then I should file, my lord. Rejoinder, if rejoinder, my lord.
Rejoinder by you. Then office note says that rejoinder has not filed. Not yet filed.
No such order.
Well,
I don't know why.
How it?
Huh? IA. IA, you have an objection.
Yes, ma'am.
You have filed the objection.
Yes, I have only filed.
I think on that you may have, you would like to file an.
My lord, but so far I remember, my lord, I have not submitted.
Last time, what is the order? You have not appeared last occasion.
No, my lord, I was not there.
So there's a paucity of time. You are objecting seriously.
Yes, ma'am.
Condemnation.
So,
List.
such situation, my lord, hearing will be required.
On the prayer of learned counsel for the, then it has to be listed for orders.
My lord, in orders to dispose of the IA, my lord, but to the condemnation.
List
process.
after a week. On the prayer of learned, Mr. So-and-so, C. Modi learned counsel for the applicant, and Mr. O. Modi for respondent. On the joint prayer of learned counsel for the list this matter after 2 weeks. After a week. Yes.
All right.
But this is an application for pausing the proceedings.
What?
Pausing a criminal proceeding which was initiated in 2009. And after 5 years, the case is stalled because prosecution has failed to produce witness. For the 5 years, there is no development in the matter. LCR has come.
Which one? In IA. You tell them. It's okay, they are not. Yeah, what is to be done today? Why this has been listed for orders?
Last occasion, my landlord appeared for the informant. That was kept.
Is there a private respondent?
Private respondent was there.
How many?
Only one.
Are you appearing?
Yes, Proceed.
What do you want?
Proceed, kindly this may be adjourned for today also.
And Mr.
G. Bol.
G. Boro.
Bol.
G. Gore.
Bol. BHOL.
Bol. Bol. What is to be done? Admission.
Let it come out.
Service is completed.
If service is complete, then list the matter for admission hearing. Your
Mr. Admission. You record the name. Service complete. Service is complete. Service is completed. List of list for admission hearing after 4 weeks, 3 weeks.
Can it be 28th? Because 28th another matter, so I am coming.
28, 20.
Yeah.
20 or 28?
28.
28.
28.
28/06/2024. Next.
Okay. Let it come to the admission and let it come to the admission and hearing orders.
Admission hearing?
Yeah.
Yes.
Yes. This is a joint application, criminal petition for quashing of FIR. The FIR, the settlement was entered just after 32.
Why this is listed for? Why orders?
Your Lordship, CD was called for, we have received the case diary.
Case diary?
Yes.
Joint petition?
Joint petition.
Joint petition.
Next week for admission. And then consent for it, and also Mr. T at the learned additional PP submits that he has received the case diary.
The case diary may be retained, Your Lordship. It's an original case diary.
List this matter for admissionary after a week. The learned additional PPT will retain the case there.
Deeply,
Next week, huh?
deeply obliged.
Five o'clock.
Lordship,
It's not possible today.
yes. Can it be on 12, Lordship?
Where this is. Who is, you are appellant?
RFA, yes, no, Lordship.
No, I'm for the appellant, Lordship.
Appellant should be this side.
Yeah.
That side.
This is land dispute between two blazes, Darka and Nobdir. Sorry, Lordship, Tabin blaze. They can consent from the council for the appellant, can it be on 12, if Lordship permits?
It's of 2004. Judgment is of 2004.
Yes. Lordship, here, there was a delay of 5,868 days. That was also condemned. Ex parte.
Very strange. We'll say, will you go back, both of you? File a fresh suit. We'll condone five next days again. We'll see. We'll see.
Yes.
On the, and Mr. K, no, Mr.
D. Lonas.
D. Lona, learned counsel for the petition, appellant, and Mr. K. Lona for respondent, learned counsel for the respondent. And the joint prayer of learned counsel for the parties list this matter on 12th. 1/2/06/2024.